Yes.
Actually, I recommend from item number 17, which is option of my brother also. See, in this case, what I have to obtain some instruction. So, what will make it go with that?
Okay, Mr. Take over.
This is
Is granted COVID time. So fair instruction. And file affidavit is next. Is the matter.
very good. Not extremely sorry to mention on a very urgent basis that the stream of a great petition today, your lordships. Now, today in Parkside BTC, there is an election process which is happening. The Labour Commissioner has now passed an order adjudicating a dispute between a management and a Labour and directing for a revocation of an order of a lockout. Now, they have already threatened that yesterday, 2 days before this order was passed. Now, he's gone beyond the jurisdiction to pass an order and direct that the tea garden be opened. There's a huge
What we open?
the tea garden, which was actually closed by the management. Now he's revoked that order, inner constitution proceedings under section 4, appointed under section 4, and passed an order for direction to the revocation order, the order be revoked. Now the problem is there's an election today, and they have already threatened us yesterday to get out the entire management. I'm only requesting on Lordship, it's not a very big matter for Lordship, can respect today and hear me, that's all I'm requesting.
Is this matter pertaining to this way?
Yes, industry. I'm only requesting this is your Lordship for today.
Let's see if it comes, if it can, at the end of the day.
Extremely good. May I please your Lordship, in item number 40, Lordship, they have filed an affidavit supplementary.
Yes,
So it may call for fine.
item 40.
Yes.
Okay, right.
Lordship, we have filed the affidavit according. May I please your Lordship, my lord, I think mention for listing, my lord, on Monday, my lord.
What is the matter? New case?
Need the promotion, my lord.
Promotion?
Yes, my lord.
Promotion is not this bench.
Number 36,
Bench 3.
38.
Yes.
You have filed the affidavit yesterday.
38 you have not filed.
So, sir, I know there was some defect that has also been
Clear, sir.
yes. I don't know.
Huh?
I don't do that.
Okay. Yes, sir. It is there in 36 and 37, it is there. 38 is not there.
And there was a defect in the
Okay.
that is I beg to mention for listing order or not matter.
No question on that. What is the matter about? Huh?
Order for direction.
Order for direction for what?
Not pensionary.
Pensionary benefit, this is not the bench. Bench 3, I think. Bench 3.
With the process of the petition, I take the item for 60.
16.
60, not 6.
1 6, yes. What is the matter about?
The difference of the petitioner is not been finally bill. But the petitioner was in holiday leave. And the signature,
Holiday leave?
yes, Lordship.
So what do you want?
The Lordship, I need 2 weeks time to give instructions of the property. And for the respondent number 1 to
Item 16.
yes, sir.
Yes, who is appearing for the petitioner?
I have taken concept of the
What is your name?
R. Tapati.
R. Patati. Tapati. Then it's also for the respondent number 1 to 5. Praise for time to obtain instruction. And submit that he has taken the consent of the petitioner firm. Accordingly, release this matter after 2 weeks.
Mention item number 15.
Yes.
We have received the affidavit in opposition. Kindly, please send me the traffic.
You are claiming interest.
Yes.
Huh? You are claiming interest. Miss, what is your name?
D. Mohanta.
Miss D. Mahanta appearing on behalf of?
Uh,
Huh?
on behalf of
On behalf of Miss
8th of
A. Chakrabarti. Then it's also for the petitioner. This is after 2 weeks time. 3 weeks time to file affidavit in reply. Or what?
seek instructions.
With regard to what?
Lordship, he is an elderly lady, but
Madam, he's old, fat, elderly, doesn't matter. On what ground are you, what instructions are you going to ask?
file
What?
reply not.
With regard to what point?
Lordship, they have filed the affidavit in opposition.
Correct?
So we need to seek instructions.
What is the point that you want to address?
Lordship, they have stated that they have made an agreement
whether the interest should be paid or not.
Have you read the agreement?
There has been no agreement on this. Since
So then what is there to be, so what is there to counter if there is no such agreement?
Customs letters are one.
Okay, granted to 3 weeks time to obtain instruction and file affidavit. Said everything reply, give this thing. This is the matter of the case. Yes,
Well, with the consent of the other side, I beg to mention item number 22, ma'am.
yes,
I am appearing to the respondent. Well, we are filing affidavit today, ma'am.
you're filing affidavit today.
That will come next week, along with
Mr.
SK Chakraborty.
N.K. Chakrabarti,
Standing on the EPFO. Provident
Standing
Fund.
Council EPFO submits an affidavit opposition is going to be filed today.
Yes.
Accordingly, release this matter after
Next week,
2 weeks.
apply. My please, the Lord, so I beg to mention for no registration for addition there. Anything next.
It's an old matter.
Yes,
Give a date. Next month.
next week.
Sir, please, your lordship, the concern of other side, making it item number 20.
20, yes.
We have to file lordship, affidavit in opposition matter. I'm applying for respondent number 9 and 10. The ministry was included later on.
No. What is the problem?
Instruction is received, but the copy of the affidavit has not been received.
What?
Copy of the affidavit has not been received by us.
By you? By respondent number 9 and 10?
Lordship 9 and
Show me the writ petition. Who is the query for the petitioner?
I'm okay.
It's regarding registration of that auction vehicle. What is the difficulty?
For last 4 days, 1 year, I think,
the ministry was included later on.
Maybe you appear, we'll ask him to appear that 9 and 10. Tell him to come. When will he come? Huh? Who's your senior?
Edge Gupta.
Huh?
Edge Gupta.
Who?
Edge Gupta.
Tell him to come. We'll pick it up.
Math legal lordship.
Huh?
Math legal lordship. But I beg to mention for listing of the whole matter lordship regarding past institution, they are agreed by the order of the Secretary Committee.
I'll give next month something.
The next one.
Meet please, your lordship. Lordship, I beg to mention for listing of a WPC admission law on 30 April.
Right, Sati?
Lordship, as per my senior instructions, Lordship,
What is the matter about?
Lordship, the excise shop was awarded to us, Lordship, but then, unsuccessful bidder filed a writ petition, Lordship. And now there is a state operating in their favor.
So you have filed a stay vacating petition?
Lordship, we had filed affidavit in opposition.
You filed an affidavit in opposition. They have not filed reply. Okay, missed it. Okay. It's okay. The next,
I am going for listing of matter for two in all matters. I think it is a next.
give a date.
Meet please, Lordship. Lordship, I beg to mention item number 14 of page dated. Lordship, we have taken consideration of the other side. We have to file a affidavit in opposition.
Mr.
M. here, Lordship.
M. Brianna, counsel for the respondent number 4 is granted 2 weeks time to obtain instructions and file affidavit. Give the matter after 2 weeks.
I beg to mention item number 18.
Item 18.
Yes, sir. There is another matter, WPC 5330, relating to the same writ petition. Sir. So the letter may be taken with each other. Sir.
Wait, yes. No, where's the affidavit?
We have received, we have.
Have you received parawise?
Yes, Lordship, and maybe we have filed the affidavit in the other matter, my lord, that is why.
No, we do not. Right, it's Charlie Ha. Direct counsel for the health department. Submit that he has received parawise comment and will be filing affidavit of position within 2 weeks. This matter along with WPC number
5330, Lord.
550 of 2023.
That is 3 weeks.
3 weeks. 3 weeks.
For listing of a requisition, your lordship, can it be taken on 3/5, your lordship, next week? There's some urgency there. 3/5,
What is the matter about?
it's regarding realization of contractual bill, your lordship.
No hurry.
Lordship,
No hurry. No hurry. Your contract pertain to which period?
It was,
12,
1819.
1890. And when did you file the writ petition? 22, after 4 years. And there's no hurry.
Already
There's no-
admitted them on the lodge. 13 dollars. May I please the lodge? I beg to mention item number 31.
13, yes.
Senior counsel Mr. Saibala is not available to the person. I've taken the consent from him. After 2 weeks,
Who is appearing for the other side for the railways?
PK Das.
Where is he?
I have taken it from
What is your name?
HK Son.
Mr. H.K. Sharma, prays for adjournment and submit that you're taking the consent of Mr. P.K. Das. This is the matter after 2 weeks.
Much so.
May I please allow? Yes, I'm sorry. I was listening for motion matter.
Huh?
Listening for motion matter.
Yes.
Only my
What is the matter about?
lord, matter about my lord, the petitioners are the consumers of the fair price shop, my lord. Our fair price, my lord, shop is at a tax with another fair price shop, which is my lord, Lavakpa Part 3.
Tuesday, Wednesday.
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 Yes, your lordship. I beg to mention item number 9.
9. Yes.
Some more information is required in this case
Wait, madam, we'll see. What information is required?
regarding the fees.
Huh?
Regarding the fees,
What bill?
non-payment of contractors.
Isn't it a covered matter?
Consent.
Isn't it a covered matter? No. Have you read the file? Have you read page 113? You have not read. You read and you come back.
Yes, your lordship, we have filed this contempt petition against the Deputy Commissioner of Nogal District, my lord, and at that time, Kodai district was abolished by the government.
Will contempt lie out here?
Yes, my lord.
Will contempt lie?
No, my lord.
Then why are you filing contempt case?
But my lord,
If contempt doesn't lie, why are you filing a contempt case?
WPC order was filed, so contempt lies, my lord. But my lord, as now Hosai district is reshuffled and restored, so we want to withdraw this contempt petition and liberty may be granted to file a new contempt petition against the decree of Hosai.
I don't know. Anyway, right. Okay, right. Third bit. What is your name?
J. Bedbura.
A. Bez Barwa.
Yes.
Then it's possible for the petitioners to submit that he may be able to withdraw the present certificate with liberty to file a claim. Is allowed. The present contempt petition is dismissed as withdrawn with liberty as well. This shows as withdrawn with liberty as well.
Okay.
The matter is
Yes.
in your instruction is not, we have a set of,
Wait.
they stated that they will again place before the committee, Your Honor. It is in process. Earlier, it was placed on 17/2. 72, a meeting was held, Your Honor.
Why is it not be you in the last order?
Page 70.
They said that it has been sent to the Pollution Control Board by the circle level permit committee. And now you're going to send it afresh? Why? You've taken it back or something?
Perhaps not if it is in a process.
What do you mean perhaps? There's nothing
We
perhaps.
have not
You
received.
see, there is something definite in the last order. Are you saying that what we recorded in the last order is a wrong statement made by you?
Lordship, all I'm stating is that it is in process. Documents are being asked from the petitioner. The petitioner is being assisted to.
Mr. Counsel, the thing is that this matter
Everything is available here.
is just an issue of yes or no. There's nothing beyond that.
The only thing is that a lot of there's a certain level committee that also comprises of revenue officers. So that committee jointly decides to whether allow the stone factory unit.
It's actually, the stone factory unit has already been allowed. It's like, in fact, the renewal of the said license.
It is a renewal,
Renewal of the license. It's not something new.
not fresh.
So when will you decide? Or we call the officials here. Who is the concerned official who is to do it?
But
Who is the main person?
committee, the permit committee. Okay, I'll get the updated instruction.
Where?
In 2 weeks or
No, sorry. By 2 weeks, even I'll forget why it was so urgent. So these are simple things. You have taken time earlier. Only on the ground that it was to be decided and the papers have been sent to the concerned authority. Now you're taking a different stand. Either you're lying or your clients are lying to you.
a lot of until very recently, 12 April, one a document was required that was asked for and has been submitted. There's this certificate called Udyam Registration Certificate.
We'll list it next week. You get definite instructions. Mr.
I got.
I brought up can obtain definite instructions by Wednesday as to whether the petitioner's application for renewal of the license for running the stone factory unit has been decided by the Pollution Control Board. Inasmuch as the order dated 3/4/24 has stated that the petitioner's application had been sent to the PCB by the circle level permit committee. This is the matter on. For what?
Reason leak.
Huh?
Reason leak.
What is the matter about?
Matter is about the non-payment of protection.
Not the. So is there any admission?
Yes.
Where's the admission?
At page number 28, because where they have the branch manager Assam Corporation has issued the salam to us.
It is your bill, Mr.
Yes,
Counselor.
this is the salam method. They have the method.
We issue notice, that's all.
Yes, sir.
Heard, Mr.
Vidas.
Huh?
Vidas.
These are Senate counsel for the petitioner who submits that the petitioner has not been paid his bill amounting to rupees 7,58,560 for supply of 480 kits KITS of hybrid vegetable seed. Issue notice returnable in 4 weeks. Who accepts notice?
Lordship, I'm appearing for respondent number 1 and 2.
Mr. Speaker. Please everybody accept notice from the respondent number 1 and 2. 1 and 2. While Miss
RM Parvat.
RM Barua accepts notice from the respondent number 4. What about 3? Assam Seed Corporation Limited.
Lordship, there is a standing up.
Who is it?
After Mr. A. Sappa.
Or you will take steps otherwise? Petitioner will take steps for service of notice upon the respondent number 3 by registered post daily within 3 days. This is the matter of the poll. Okay.
Yes, by this petitioner is saying for a direction.
Did you make a claim?
In fact, petitioner approached this on the court and the court allowed if you doesn't your lawsuit will find it in a case. circular dated which was issued on 18/6, it was.
No, but when did you make a claim? Prior to 18/6 or after 18/6?
18, right, it.
So you just see, if he has made a claim prior to 18/6, then he's covered by the judgment, by that order, not judgment. Okay. By the order dated
873. In fact, I am paying for a direction from here to one part.
No, order dated 22/6/2024. It's only only for that, for the period prior to 18/6. If he has made a claim prior to that. So you give as per this order, that's all.
Even they can verify, Milo. There is.
No, at the time they can verify and then
They can verify.
okay, right. Heard Mr. S.K. Kejriwal, Learned Counsel for the petition, to submit that the respondent should be directed to give interest subsidy to the petitioners in terms of the CISS, 1997 and CISS 2007. Before that, you see, in terms of the Central Investment Subsidy Scheme,
Central interest.
the Central Interest Subsidy Scheme, hereinafter referred to as the CISS, 1997 and CISS 2007 for the period prior to 18/6/2014 as per the judgment and order dated 3/6/2018 passed in WPC 2012/2014. Correct?
2074 of 90. Earlier read it is. Yes, 5647. Sorry. 5647 of 90.
And and order dated 22/3/2024 passed in 5647 of 2009. He submit that the petitioner had made a claim for disbursing the interest subsidy claim in terms of the above two schemes prior to 18/6/2014 and as such is entitled to the said claim in terms of the two schemes. Gupta. Next, Mr. H. Gupta, the learned for TGC. No. One. There are counsel appearing for the respondents number 1 and 2, and Mr. A. Kalita for appearing for the respondent. What here? TGC or what? Okay. What is it? Huh? Okay. So here as additional age, what is it? No, that for standing counsel, no, just say standing counsel appearing for the respondents number 3 to 6. Submit that so long as the petitioner has made a claim for payment of interest subsidy in terms of the CISS 1997 and CISS 2007 prior to 18/6/2014, the petitioner would be entitled to the interest subsidy scheme, in terms of the judgment referred to above, in terms of the order referred to above. Correct?
As well as the notification.
And actually, that's next para. On perusing the no. In view of the submissions made by the counsel for the party, and after perusing the Order dated 3/6/2018, passed in WPC 2012/2014, and the order dated 22/3/2024, passed in WPC number 5647/2019, comma. The respondents will verify as to whether the petitioner has made his claim for payment of interest subsidy in terms of the above two schemes prior to 18/6/2014, and if is entitled to the same, the said interest subsidy should be given to him in terms of the CISS 1997 and CISS 2007 for the period prior to 18/6/2004. The same should be done within a period of 3 months from the date of receipt of a certified copy of the document. That is,
Yes. By way of passing it.
okay, by way of passing over, speaking order, the writ petitions accordingly.
Liberty may be given to SLD notification. It was
No, that is always there. You cannot claim on the one hand and take, it's either it goes or doesn't go. How can you do that? That is not
like-
fair.
5 and 6.
Okay, same order.
Hey, below. Only the read petition number, earlier read petition, it was in respect of the Assam group,
Assam?
Assam routing, but my read petition numbers are different. Yours were referred to 2010/2014, but my read petition numbers are 2074 of 19 in first case. And in
No, your other writ petitions are with regard to something else. Subsequent to 18/6/2014, that judgment passed by Justice Dekha, that has been superseded by this notification. This should not apply. Please don't be too fast. It's got to be fair to the court. Petition, whether relates to non-payment of rent, so that is the public sector. Okay, right. Third, Mr. F. Kutubi. There is counsel for the petitioner who submits that the petitioner has not been paid rent amounting to rupees 6,79,797. Issue notice returnable in 4 weeks. Mr. X. Roy accepts notice on behalf of all the respondents. This is the matter after 4 weeks to enable the respondent counsel to obtain instructions and file affidavit. In this case, my lord, in view of the order passed by the government, I am not facing this application. Is it still day-to-day basis? Day-to-day basis, there has been, the government decided to cancel all. And therefore, that order. Okay, that order. Okay, right. In view of that order, I am not facing. Okay, right. Mr. S. Pataki. I can't read the number. What is the number of the letter?
Lord, number second page,
second page clear.
withdrawing, then
Naturally, he is withdrawing. He's not pressing.
he is not made the party with.
He said that he is withdrawing. He is not pressing. Mr. S. Pataki, learned counsel for the petitioner, submits that in view of the order number. What is this order number? Can't read. Second page memo number, my lord. Second page. ECF. Order number ECF. E small, C capital, F capital, number, full stop, E capital E dash 268956 slash 262 dated 12/4/2024 issued by the Commissioner Secretary to the Government of Assam Fishery Department. He is not pressing this matter. Full stop. Mr. S. Roy appears for 1 and 2, while Mr. K. Mohammed appears for the K. Waiter, respondent number /respondent number 6. Good, sir. in view of the submission made by the petition counsel, the repetition dismissed as not fit.
Right.
As the cavator has appeared through his counsel, the caveat stands inside. The order dated 12/4/2024 is made a part of the record and marked as Annexure A.
The purpose is
Covered case, then why are you asking for the judgment?
this one.
Huh?
It's 122.
122. Yes, Mr. Roy. Who is for the other side? Huh? Let him come. After some time.
My lord, they have filed their affidavit, but they have not answered your lordship's point.
That's what, I
Very unfortunate, my lord.
I have not understood what they're trying to say. Also.
Yes. So, my lord, this is an action which the lordship will not take very lightly. Is it unintelligible to them, your lordship's query? My lord, what is wrong in it if a respondent concerning a case? Is it necessary that every case is to be, my lord, contested tooth and nail, despite the fact that there is nothing in there? My lord, your lordship's simple query was whether that particular document is there or not. Lordship has clearly said, even if you file an affidavit, you answered his question. They have not answered that. Instead, my lord, they have stated so many things which is not at all required. I'm very sorry to say that. Repeat it, sir. I'm sorry, 1 minute. If your lordship would kindly have your lordship's order dated 22/4.
Yes.
Last para, my lord.
Yes.
In the event respondent file an affidavit on or before 25/4/24, respondent number 4 needs to appear for this. However, the affidavit should specifically clarify the issue raised by this person.
I have got, what is it? 1581. 1581 is the first case matter. 1581 I have got. I have got. I thought my first case was connected to the 5 yesterday. They are quite competent. Right. That's very nice. Now you're also very low opinion of the registry, sir. You've got. So in fact, we are also pursuing because there was a trade of personal affairs. And therefore, we are pursuing the matter. Now the answer to your office query matter. Their case is that the rejection is on the ground that a temporary alteration of registration certificate for the network, my lord, that has not been submitted. That is a pre-qualification document related to the truck offered. Now, my lord, this case primarily, my lord, based on the fact that in another tender, the same truck has been accepted with the same papers, and no, besides that, that is that is not that. He has not used that. You all have interpreted that way. His basic case is that in this particular tender, He has given this temporary authorization of registration.
Your lordship, and then see, madam, what is the requirement? Now, in paragraph 6, 7, and 8, madam, we have explained.
No, let us see the tender, the tender condition, the specific tender condition.
Tender quotation, the repetition, my lord.
Page
Page 73, the pre-qualification document will be uploaded.
page 73.
73.
Yes,
Criteria, crop ownership, owned, attached trucks. PQC document to be uploaded for owned attached trucks, self-attested copy of form number 2328, RC book, smart card, or invoice accompanied with temporary registration certificates, temporary authorization of registration certificate for new trucks. Now, my lord, this requirement is for new trucks. My lord, the temporary authorization, what they have annexed is a, my lord, temporary authorization. And it's not a new truck. And that's why, my lord, the confusion of the petitioner arose because of the fact that, my lord, in the another NIT that was accepted, and why not this? That may be the confusion, because they have uploaded the same set of documents. But, my lord, the criteria in both the tenders are different.
wait,
Yeah,
out
this is
here,
clear.
whether it's a new truck
This is my
or
lord,
you see, when you look at the criteria says truck ownership,
truck ownership.
owned slash attached truck. It does not make a differentiation between new or old.
Possible kindly take note of the fact that, my lord, the inverted comma starts with invoice. And invoice is in respect of a newly purchased car.
Yes, attested copy or of form or invoice accompanied with
Yes.
temporary registration certificate slash temporary authorization certificate for new truck. So it only has, so if he submits an invoice accompanied with temporary registration certificate, that's enough. Does not have to be new truck.
No matter that invoice, my lord, why the invoice is there? Invoice is there because, my lord, it has to be a new truck. Then only, my lord, there will be a invoice.
No, but why do you have, so invoice is required for both, according to you,
Invoice is required for new truck.
for new truck?
Yes.
For new truck. And for old truck?
For RC book will be there, my lord. For old trucks, RC book is there. Your lordship will see for owned attached truck.
Then why do you see after invoice accompanied with temporary registration certificate slash? Why is this slash necessary again? It's a why a repetition of the first portion? Temporary authorization of registration certificate. Again, why? For you, it's the same thing.
Invoice accompanied with temporary registration certificate,
Slash.
temporary authorization of registration certificate for new truck.
So it's the same thing. Why should there be a repetition of the first part in the second part?
This is because, my lord, the earlier part is with regard to the, my lord, already existing trucks which are already registered, they have got the registered group, and this is the alternative for a new truck. New truck, my lord, has to be accompanied by invoice. And it is not the case that it's a new truck, we have bought it now, we have yet to get the registration book, and therefore the invoice is done. But without the invoice, my lord, that's not accepted. Your lordship will kindly see, my lord, what way back, my lord, the manner. In fact, my lord, on this ground, many other trucks have also been participated. They are the petitioner is before lordship, but there are other my lord, tenders, those have also participated. Now, in the affidavit, my lord, we have stated about the previous tender, and my lord,
What is this tender? What is you are talking of two tenders in your affidavit.
Right.
Now this tender is which tender? What is the date of this tender? The
this
present
tender
tender.
number is, my lord, the earlier tender is it ends with 2014, and the new tender it ends with 23-24. Floated on 24/11.
So we are with this 23-24.
Fine. Dated 24/11/2023. In fact, my lord, this, on this ground, the same thing happens in different places also. It's a size of artists, so also my lord, we have to take it different. Other places also, the same thing has happened. So this will have an understanding there. Whatever your lordship is saying. So this is our stand, my lord, this report is something. If your lordship then comes to our ability,
Your own attached structure, whether it's a copy of form 23. What is this form 23?
23, 23. In fact, my lord, we have annexed the entire documents. They have, my lord, file.
No, besides that.
23, 23 is my lord, there is a registration. That is my lord,
And 23A is the smart card.
form number 23, 23 for existing and registered, 24 for registration. Okay, sir.
What is 23A? RC. 23 is the RC book.
One the RC book, the other is the smart.
Okay, so 23A will be the smart card.
That is issued the regarding the registration in trust. It says 38 is scheduled, the answer is page 30.
And we have this complaint case, my lord, because at being 115, we have given a charge to show, my lord, what is the difference between the earlier tender and the present tender. Put this up.
Page 38.
338, yes.
First is application number,
Yes.
second registration date, 3rd November 23. And
Ah.
if that is not a new trust, then
Yes.
what would be a new trust?
Yes. 3rd November 20.
If that is not a new trust, then
Huh?
what is a new?
Then invoice has to be there, my lord.
What has happened is that before
Did you submit your invoice?
what has happened here that nowadays the RC and everything is given by the dealer itself. But during that time, what has happened is just before they got this thing, the RC comes to where research. Till now, we have not received it through it. If we do not receive it through the DPO office, that is a certificate which is there, and we have given in our statement. We have with the RC which has been given. The veracity can be ascertained just by a QR code, which I have given. They just need to look at once and it will come immediately.
So this page 38 you gave it.
Yes.
Yes, it page
And it is
38.
admitted by them also. We gave it, this is a thing, this is a requirement by them. And the two tenders that they were talking, that has been talked about. The first tender is a Skopje Parish. And wherein we have shown,
You give the temporary authorization of registration certificate.
yes, this is the temporary authorization.
This page 38.
This is the temporary authorization.
So there is two parts. It appears. One is the invoice with the temporary registration, and one is only the temporary registration.
Yes, this we have given.
Otherwise, it doesn't make sense to repeat the first part and the second part again. If it yes, brother. Otherwise, then, what is the purpose of having a slash?
Yes.
Why that second part should have been deleted altogether.
And actually, this is a probably a cycloset tender condition which was there from earlier. Now with this change in thing, they have not, that's the temporary, this part, you would have given if the original which was with her, why would not have been given it? It is not given by the government, then where can we give it?
So that is the requirement is you have not.
And I have bought a new truck for this. Now again, this earlier, I am a distributor.
No. Just, you see, the simple issue was this. Whether this temporary authorization of registration certificate has been given, page 38, whether it was given. That's all.
Admitted.
The entire document have been annexed to.
Let us see where is it.
We have annexed, my lord.
Where?
Temporary registration. They have given this. They have got this, my-
Yes, it is here, page 123.
123 is their document is given.
Now, my lord. But without the invoice.
Yes, correct, without the invoice.
We are not saying
Now, my lord, may I please one document I have received yesterday, which is the government of Karnataka, of course. Just to my lord. show that, my lord, the access that they have given, my lord, at page 123,
The extra,
my lord, page 123, my
yes,
lord,
yes,
that they have given, my lord.
yes.
This is, my lord, temporary permit.
Temporary,
This is a temporary document, my lord.
correct. It is temporary authorization.
And, my lord, the government of Karnataka, my lord, in this order, which I received on the last 15 minutes, says that the access is not a substitute for the original rate.
Maybe, but then this is your advertisement. This is your NIT. We are not on what Karnataka NIT had been, what NIT had been published there. We are only on the issue of what the NIT here says.
Yes, sir. But the same terms and conditions are not followed.
Maybe. I do not know. That is, there is nothing to that effect. It is by you in your residence.
So, my lord, that particular document has been annexed, but the invoice was not annexed. Now, if your lordship holds that, my lord, because of this plan, the invoice is not required, my lord, that is up to your lordship.
Yes, sir. Another thing, so what is the reason for disqualifying the tender of the petitioner was basically that only.
Yes,
Yes. To consider it.
So far, my lord, this particular specific contract, two cases are, my lord, I said to say,
Yes.
Talapahar and
Hello.
and hello.
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 There are two, in 1581, there is one vehicle, sir.
And the other
And in
is two ways.
1582, there are two.
The third one,
Is there any impugned order to be set aside? There's nothing.
Only thing is, my lord, the cancellation part.
Cancellation of,
Why our tender was cancelled, that is the input of summary report.
where is that page?
Yes. One.
Eighty-six. Huh? 86.
Page 86.
One, two, three,
Eight. 86.
no, 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 this is for me. One more, one more. Oh. Hold on. Allow me.
Where are you?
One, page to page. Page 86, my lord. What? Hello, huh? Page, serial number.
Page 88.
Page 88, my lord, serial number 33.
This is for this
81.
1581.
And if you also could kindly come to page 87, serial number 26 is the other one. Then,
There number 26 for the other case.
yes, bidder has not submitted secrecy document
That is for
related.
1582.
Serial 26 is 1582 and serial 33 is, my lord, 1582.
Okay. Right. Urge with the K.N. Chaudhary, learned senior counsel for the petitioner, assisted by Mr. Yes,
Ajay Das.
R.K. Das. Also heard Mr. M.K. Chaudhary, learned senior counsel for the IOCL, assisted by Mr. P. Badwa. Next paragraph. The petitioner's counsel submits that the petitioner has got one truck bearing registration number AS01 RC1545. The petitioner participated in the NIT dated 24/11/2023. However, write the summary report dated 27/2/2024, wherein the petitioner's name appears at serial number 33. 33. The petitioner's bid was rejected on the ground that the petitioner had not submitted PQC documents related to the offered truck. PQC is the short form for pre-qualification criteria. And in terms of the PQC provided in the NIT dated 24/11/23, the truck owner is to upload self-attested copy of the RC book slash smart card or invoice with or invoice accompanied with temporary registration certificate slash temporary authorization of registration certificate for the new truck. Next paragraph. Mr. K. Chaudhary, the learned senior counsel for the petitioner, submitted that the petitioner having submitted the temporary authorization of registration certificate for the new truck bearing number AS01RC1545. The petitioner has fulfilled the requirement of the pre-qualification criteria required, and as such, the rejection of his bid on the ground that he did not submit the temporary authorization of registration certificate for the new truck was without any bid. They accordingly submit that the petitioner's bid. They accordingly submit that the rejection of the petitioner's bid to be set aside, and the petitioner has bid to be considered along with other valid bidders pursuant to the work to be provided in terms of PNIT dated 24/11/2020. Next paragraph. Mr. M.K. Chaudhary, the learned senior counsel for the IOCL, on the other hand, submit that what have you submit?
That might not, the instruct has to be, might not, along with the
Invoice.
invoice.
Submit that uh, the 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 truck owner has to submit an invoice along with the temporary authorization of registration certificate for new truck. So, as the petitioner did not submit any invoice along with his temporary authorization of registration certificate, there was no infirmity in the respondent rejecting the petitioner's bid, as the same was not in accordance with the pre-qualification criteria required in the NIT dated 24/11/2023. I have heard the learned counsel for the party. When you write the pre-qualification criteria for bidders offering trucks provides as follows. Page 73, you take from here to it. 73. A perusal of serial number 1 of the chart shown above shows that for owned slash attached truck, the bidder would have to submit self-attested copies of the registration book or the smart card. If the same was not possible, the bidder was to submit an invoice accompanied with temporary registration certificate for new truck. A third category has been enumerated in serial number 1 in respect of the PQC documents to be uploaded. Wherein it has been stated that temporary authorization of registration certificate for new trucks should be uploaded. It is clear that it is clear from the chart shown above that the bid of truck owners would have to have either of the three documents as mentioned there. There is nothing that there is nothing stated to the effect that no the third category of document required of a bidder clearly provides that only a temporary authorization of registration certificate for new truck can also be considered even in the absence of an invoice. The document submitted by the petitioner with regard to his new truck, which is reflected in page 123 of the affidavit in opposition filed by the IOCL, shows that the truck bearing registration number AS01 RC1545 was registered on 3/11/2026. And as the NIT pertains to as the NIT pertains to the date 24/11/2026, it is clear that the petitioner's truck was only uh, 21 days old at the time of issuance of the NIT. The temporary authorization of registration certificate for new truck having clearly been submitted by the petitioner, this court is of the view that the rejection of the petitioner's bid by the respondent authority was not in consonance with uh, was not in consonance with the pre-qualification criteria provided in the NIT. If that be the matter, the rejection of the petitioner's bid in serial number 33 of the tender summary report dated 27/2/2024 is not updated. The same is accordingly satisfied. The respondents are accordingly directed to consider the case of the petition for allotment of transportation of Indian LPG cylinders in terms of the NIT dated 24/11/2020. Provided that the same, provided that the petitioner sent up. And that's all, that's what they provided. That's the only ground for the writ petitions accordingly allowed. Because the incident also might have orders to other six to accommodate the petition of statement to six. Therefore, मतलब my show is big about that. It's not related to this because मतलब other persons rejected things not directly have an effect.
came on time. They came on time. Other than not, they process complete.
He's thinking he's lining up his potential repetition.
So the mother process.
His
Except for 6 trucks, concerning these methods.
out here there's only three factors.
No, here and another, the last repetition there. So these stuff were kept, the LOA has not been issued. Now we have to give. Foundation for work order has to give.
But how can we deny them?
Yes.
You see, it's only of November, supposing it's after a year or so or something, then that's a different thing. Because that sitting on the fence, that judgment can come into effect. But then this is only of November and
December. 10 days of December.
no, 10th of November, 24 November. And when did you issue the LOC, LOA?
The last date was for, last date of commission was for January. January, sir. It was issued in November, but its original one was extended.
Then they'll take care there.
And this year might not be fair, the petitioners have come on time. In fact, there are, clients have come where
He has got, I told you, he's got a line of
some
clients.
other bottling agent there, the RC has been, forged and submitted.
That's
That is a, I'm saying, these are the things which are happening, but that I think it cannot. Only an observation,
What, observation to what effect?
that it will not be created.
Difficult. If it was a long, say at least 1 year had gone or something, some period has gone. But it's not the thing.
30 January was the last date of.
Why you want to limit his bank account from growing? He's
So it
thinking,
won't come to me.
that those persons are there, they're going to come now. Dollar signs are ringing now.
But the supervisor third case is concerned, like, I think it's different. They just not kind of submitted the
Bid declaration, bid security declaration.
that is not something to have annexed it, I don't think.
It is not submitted yet. End of the matter.
Then-
The question of fact.
No, they have asked for the document from other bidders. That was our prayer. Page that,
Okay, they asked for the bid declaration, bid
No,
security
they-
declaration from other bidders.
no, not bid declaration. Or Lordship may take, one.
No, just a minute, just a minute. In the second one, in this item 37, there, just give me item 37. I'll just give the, everything is same,
Yeah.
except the truck numbers are, there are two trucks out there. AS01 RC 0745 and AS01 RC 0746. Okay, and in that summary, no? In that summary,
Is
the
that
serial number is 26.
26, serial number is 20.
Serial number is 20. Okay. In that, in that tender summary report, huh? Serial number 26. That is everything. Okay. Kunda?
Lordship in item 38, for a moment, the affidavit filed in item 36.
That 38 affidavit has not come. That is not come.
Or extra copy is there.
He doesn't want to break the momentum.
Hello, there was some defect.
That's some,
There was some defect.
but there's some defect. Okay, let him complete since the affidavit is, he says, but what is the issue? So the issue that he's saying basically that the bid, the bid, security declaration has not been submitted according to you. According to them, it is submitted.
It is a.
Now,
Please find out the entire document, the article of document, find out the after this, we have annexed it.
that's what. Now, the issue is this. It is a question of fact. Now, when they say no, and you say yes, now do I make an order on the basis of how handsome you are, or who is taller, or what?
I respectfully submit lordship that when they had given them opportunity where the qualification documents of others has not been given, and they have been asked to provide. Okay. They have
So,
been asked to provide. Why?
Others,
By
others have been asked to provide that bid security declaration
not
form.
now that is bid, not pre-qualification document does not mean only one document. There are other documents also. Are
No,
there.
no, I'm only on this. You see, they can have some loose play in the joints. Some that is the prerogative and little bit of enjoyment that they can have because they are the ones who are going to give out the state largest, whatever. So now the thing is that the issue is whether that particular document had not been submitted by a particular bidder, but still that bid had been accepted. That is no, no, that is not his case, but then that is my query to him. You see, your case now, it appears, is that you- supposing you had not submitted that bid security declaration, you cannot say that Mr. ABC did not submit their income tax certificate, and that is why they are allowed. And just because I did not submit my bid security document, I am disqualified. You cannot. Those are different documents.
What's the page of paragraph 19 of my page 13, paragraph 9.
Yes.
If I may read.
Yes.
That it is stated that the respondent authorities have acted in colorable exercise of power by not asking the petitioner to provide bid security declaration as because the bid security declaration is not germane to the tender, while giving an opportunity to some of the successful bidders.
So that is what I'm saying.
It is committed to the main actions of the tender is that the bidder must have proper ownership of the vehicle and the vehicle should not be more than the age mentioned in the NI. In the instant case, the petitioner fulfilled both the criteria. In fact, the petitioner had uploaded the bid security. Had uploaded this is a statement of both.
That's what.
It's a statement of
He's saying that it is not. Now what to do?
Lordship page peruse the document which I have page 76. What had
No,
happened?
no. Do you have a copy of the affidavit in opposition?
I have.
Just see if it is there or not. That's all. If it is there, end of the matter.
Lordship, I have said it's not there. It's not there.
It's
If
not
you have, if you have been there, obviously they would not have been. Now, regarding this, I have given a statement saying because last day there is a history to it. Now, what had happened is that I had uploaded, and that's why this
You uploaded it within time or after the
yes,
time?
within time. Page 76 may be perused one
76 of the
of my petition.
Okay. Yeah.
This is the format. This comes as number one bid security format PDF. Yes, this has come. Now, what has happened? I have stated here also. What has happened is that this bidding process was going on from 24/11. There was an extension. On 29/11, there was supposed to be a discussion between government and the transporters. Now, on 29/11, the discussion did not happen. So 30th January was the last day. So there was a huge flow of traffic in the uploading part. This is I have given a categorical statement.
So what happened?
So that's why
So it could not be uploaded.
no, I uploaded it. Probably it did not get uploaded in the server. That if that has happened, that's what
Then whose fault is that?
it is neither my fault. It is neither my fault. That's what I want to show. Here, when they are given an opportunity to the other,
If you, when my son wanted to apply for the JVL Bombay, we had all the documents only on the last day. And on the last day, it crashed. The server in Bombay crashed. It didn't go to JVL because of few years back before COVID. No, after COVID.
respectfully submit lordship that
So then,
your son did not get, but someone else also did not get. That's what I'm saying. Here, some other bidder got the opportunity. Now, this
got the opportunity to submit this bid security declaration.
page 64 maybe look. Page 64. Just page 64 on my certificate.
Yeah.
There are 7 documents they have asked. Now, these documents, a bidder would not have submitted it. They would have submitted it. In all probability, due to that factor only, it was not uploaded. They were given this opportunity. They were given this opportunity. Now what? Probably they do not like my face or something else. They did not give me.
Probably.
Now that is where I am coming. That this discrimination is there. When they were 7 documents, not just one document, not just one document.
This document has been uploaded at the one page.
Server wise, it might be possible because one day
The page which is very wide, that has not given it. That's what the link out of any place. It's not there.
my prayer is that yes, why is this? Why?
Mr. Chaudhary, that truck has to be finished.
Yes.
Now this bid security declaration.
Yes, yes.
Now they have submitted a list of documents here. Which it does not include your document.
But my lord, the download document which we got at page 79, it says checklist here.
Now, but what?
Anyway, my lord, assuming it is not there, will it be second? That's it.
I don't.
Can you see, my lord? My lord, if the lordship would kindly take their affidavit. If the lordship would kindly come to their affidavit. Now, as far as our case is concerned, my lord, let me place the fact. My lord will kindly come to page 79.
Your affidavit.
No petition, our report.
Ah.
This is the format of bid security declaration. Format of bid security declaration. Now, my lord, the consequence is provided. Supposing one does not give it, then what happens? Towards the end, my lord.
Yes.
Then we could be debarred from being eligible for bidding award of all future tender of Indian Oil Corporation for a period of 6 months from the date. Supposing I don't give, this is the one. It does not entail my rejection. But will kindly see when a consequence is provided, then my lord will kindly come to page 76.
Yes.
This is the checklist for submission of documents uploaded. Kindly see on top, my lord, bid security declaration in lieu of UMD PDF here. Now, my lord will take one minute. Now, if your lordship will kindly take. For example, my lord, just now you have disposed of the other two matters. If your lordship will kindly take the affidavit in 1582.
Yes. It is 158.
Please come to page 107.
158. 37. That's right.
It's not there, my lord. Okay. Where? My lord may kindly have this. This is the affidavit. Yes. Please come to page 107, my lord.
Yes.
This is in synchronized with that, my lord, page 79 which I have shown. And you see, pre-qualification document consisting of the, my lord, they have deliberately not annexed this document in this case. Because if they annex this document here, they are in tough. That's why. And you see, pre-qualification document consists of the following. And you see, my lord, particulars of the firm, details of the quoted track, average age calculation, affidavit for attached track, undertaking, detail of relationship, declaration of so-and-so, certificate for no due, SCST, detail of expenses, particulars of truck offered along with scanned copies of documents, etc. Copy of acknowledged, copy of the IT return, copy of PAN card, copy of partnership deed, general conditions of integrity. So, my lord, the bid security declaration is not even a mandatory requirement. That is why, my lord, they say it will not entail disqualification. Now, my lord, kindly see what they have done. Having seen page 107 and 108, now, my lord, will kindly come to page 64 of the repetition. Page 164. Now, there is one bidder called Progoti Associates.
164.
No, 64. Annexary. That's why they have not annexed, they have not taken this stand in this episode. Now, this party called Progoti Associates, my lord, they have got several orders. Now, see kindly what are the documents which they have not provided, but they were asked to provide. This is the fairness, transparency which IOCL adopts. Land broker border declaration, capacity of truck offered by you not available, affidavit for truck offered by partnership, copy of registration certificate of farm, notarized copy of irrevocable power of attorney. You did not submit NOC for offered truck. You have not submitted properly filled in agreement of the for the integrity pack for the contract. Now, so far as this Progoti Associate is concerned, because they did not submit this, very relevant documents and mandatory documents, they were given a chance. But in my case, my lord, though it is not a mandatory document, I have been disqualified. So this is my case. So there is arbitrariness in the decision making. And secondly, my lord, this bit, what is the document? The declaration is not a mandatory according to us. This is our case.
Yes.
One of the stand taken earlier and now is different. The lordship kindly comes to the gain of the matter of the restitution. They have clearly stated that they have submitted the gift.
Now they're trying to expand. They're trying to expand.
Now,
Why don't you file a reply?
My lord,
You file a reply.
okay, I'll file a report.
Because your stand in the,
Right.
it was only on that.
We'll file a report.
Okay, right.
Only thing is, my lord, interim order will continue till
Mr. K. Chaudhary, then the senior counsel for the petition. It is granted 3 weeks time to file affidavit. This is the matter of speech.
deep level.
I think you have to take back your affidavit.
Praying for inclusion of party number 4 and 5.
Huh?
I'm praying for inclusion of the
Okay, I heard Mr. N.K. Das, learned counsel for the applicant, who submits that the opposite party number 4 and 5, huh? That is Mr. B. Kalyan Chakravarti and Mr. Anand Alal Gyani, huh? To be treated as respondent number 4 and 5. Mr. R.K.D. Chaudhary, then the deputy LGI.
I've got 3.
Refer number 3 and Mr. F.P.Das for number 1. F.P.Das for number 1, submit that they do not have any objection to the application being allowed. So, accordingly, the opposite party number 4 and 5 are treated as respondent number 4 and 5. The applicant shall submit corrected copies of the past time so that they get within a week. Within 3 days, when you write in the main case, here the order dated 26/4/2024 passed in IAC 1171 of 2024. So and so and so and so, huh? Are treated as respondents number 4 and 5. Petitioner takes steps. Now issue notice to the respondents number 4 and 5. Petitioner takes steps for service of notice upon the respondents number 4 and 5 by registered publicating within 3 days. This is the matter after full. All right. I said it goes down.
Paragraph I page 7. Do you think the pregnancy balance the earlier exponent number was has been transferred?
Respondent number? And
Exponent number 1.
okay, right. New income. Third, Mr. M.R. Conductor, learned counsel for the applicant to submit that as the respondent number 1 has been transferred, comma, the present incumbent who is the opposite party number 4 should be treated as respondent number 4. Super. This P. Biswas appearing on behalf of K. War. Learned counsel for? No, madam, this contempt. Learned counsel for the respondent, please submit that he has no objection to the application being on. In view of the above, OP number 4, the name, Sri Jai Shivani. Yes, sir. Is it treated as respondent number 4? Applicant to take steps for serving the applicant to serve a corrected copy of the cost title to the registered. I is accordingly disposed. Then in the main contempt, you write, in view of the order dated 26/4/24 passed in IAS table 1183 of 2024, Mrs. Shivani is treated as respondent number 4. If you notice to the duly treated as respondent number 4, except within 3 days, this is the matter of course. I'm
Other last topic of this one, board has directed me to the instruction matter. In that case, Malad, I have received the instruction Malad because the work has been completed, but Malad Register of Cooperative Societies has raised the Malad that the defects in art feelings and Malad boundary wall. So Malad,
defect not done. Defect work not
it has been done or not, if my instruction is not done. So that's why Malad, the Register of Cooperative Societies has directed not to release the remaining. But your lordship, the total work value was 1,93,53,000, and Malak already paid 1,78,17,000.
So how much is pending?
Remaining is for the 15,35,000 and
15 lakh 35.
35,693. And that Malak subject to problem of the defect has to be rectified because as per in the instruction, the contractor is accordingly requested to rectify the defect part of boundary wall by the order dated by letter number such and such. This is the part of the boundary.
Okay, how
wall.
much? Where is the letter to them saying that this is the defect?
Defects letter is not with Malak. So lordship will be placed to grant 4 weeks time to file the affidavit Malak, bringing Malak that
He's in a hurry. He wants to rectify the defect tomorrow. Why are you not in a hurry?
then Malak next week. That regarding the defect implemented.
Let us know at least what is the case.
But my
Probably you have got a completion certificate.
Completion certificate is here, everything is completed.
So the completion certificate is there. Handing over is there.
maybe granted Malak 2 weeks time.
Why 4 weeks?
Because government has not released the amount, Malak. We have already
Government
sent
is
for
still with the government.
government, Malak. The Register of Cooperative Societies to release the amount of rupees.
Okay,
Malak,
right.
paid
Let's
that-
give the Senate Standing Council for the ASCHF
No, Malak, house with 2 and 3.
for the respondent number 2 and 3 submit that as per her instruction, rupees 15,35,696 is the liability still to be paid to the petitioner. He submits that the payment of the above amount is subject to the petitioner rectifying the defect in the construction work. He submits that he may be granted 4 weeks time to file affidavit in a position wherein the defects to be rectified by the petitioner would be mentioned. Uh, on the other hand, Mr. S.K. Goswami learned counsel for the petitioner purpose that completion certificate and handing over of the constructed building, the building and boundary wall has been made. Uh, this due thus is granted 4 weeks time to file affidavit in opposition. This is the matter.
Only look at the
After 4 weeks. Huh?
2018 back.
The thing is that unless we get that, it's very difficult to pass a reason order. We have to see what they've got to say. This is the matter of the 4 weeks. When?
Today, 26. Okay.
Okay.
Right.
Better percentage to payment of contact.
Non-payment of?
Outstanding contact.
Huh?
Outstanding contact. Immediate liability.
What is the admitted liability? For what? What work did you do?
We have contractors. For fixed amount.
How much is
Total amount of 28 lakhs 7,300 lakhs.
item?
19.
Yes, to the query, PhD.
Yes, development. The patent of this last month, they released 18 lakhs 20,200.
18 lakh,
18 lakhs 20,520.
500.
22.
How much is the pending? How much is pending now?
10 lakhs 49,000.
10 lakh 49,000
860.
800. Okay. Mr. C. Chakrabarti, learned counsel for the petitioner submit that the writ petition had been filed for non-disbursement of the contractual dues amounting to rupees 28,70,390. So, however, rupees 18,20,522 has been given to the petitioner on the month of March. It has been given to the petitioner in the month of March 2020. He submits that the balance amount payable to the petitioner is 10,49,860.
So we have to instruct us. But the amount that's paid, like, paid,
It's gone down.
paid, paid.
It's gone down. He's been given 18 lakhs last month. Now the balance amount is 10,49,860. Is that admitted?
What's the amount that I have to keep it, the total amount is 21,30,347.
Acha, according to you, it's 21,30. Okay. Next, you're right. Ms. M. Kalita, the learned counsel for the PhD department, submits that the total amount payable to the petitioner at the time of the filing of the writ petition is it or what? Monthly.
The fund demand which has been paid, about this.
No, you see, because according to him, in March he has been given 18 lakhs. And as on date, the balance amount payable by you to him is 10 lakhs. Now, if you are going to give 21 lakhs to him, open arms will accept it.
Balance amount.
So whether that 21 lakhs includes the 18 lakhs given last.
That's
Whatever I said. Petitioner was 21, comma, how much?
21, 0,
30, comma, 347. Good stuff. Next para. Ms. M. Kalita shall obtain instructions as to whether the amount of 21, includes the 18, 20, 522 that was paid to the petitioner in March 2024. release the matter. After 2 weeks. What role have you got? Miss R.M. Barwa appears for point number 1
Official, diabetes certificate, they issue the diabetes certificate. That's got 20. They have admitted the entire.
I don't know. He has come up with some other reason. That's for her. What is that? Written instructions or oral? Huh? Dated? See. So that has not, that's 12 December. Now that 18 lakhs have been given in, I think, in last month. So probably that 21 lakhs includes that 18 lakhs given. In which case, your liability according to you would be 3 lakhs.
Yes.
Nothing. Just clarify that. Ms. M. Kalita shall submit affidavit in this regard by the next day. Huh? We can dispose it off.
Apply. Two vehicles were auctioned and it is in June 22.
Lordship, we are taking up this matter up with the vehicle, but we are facing difficulties because the vehicle was blacklisted with the earlier RTO, my lord. And
Blacklisted? What do you mean by blacklisted?
because it is shown like that, Lordship may kindly have a look.
Blacklisted for what purpose?
We don't know, my lord. It is from other state.
Hypothecated with some private finances.
Lordship may kindly have a look, page 32.
So the first charge will be with that financial.
Yes,
Yes,
my lord.
so therefore,
So
one
either they return you your money,
money with interest on the basic deposit, they get to decide.
and you have used up the vehicle also. No, then you pay the rental charges.
Now, I can't, on a petition, I cannot use the vehicle, but the registration number has not been given. And we have been trying, my lord, since the buying of the vehicle, my lord, we have been trying to get the registration done. So ultimately, we can be disposed.
When did the auction take place?
Auction took place when a tender was issued in March 20. And ultimately, my lord, I deposited, I was selected for two
You
vehicles.
deposited the money when?
June 22. And thereafter, we have been trying our best to get the vehicle registered. Ultimately, we came to this court in the year 20.
My lord, the petitioner approached the district transfer officer to have 18 to 2023.
18 to
same
23.
Very same day, page 32, we have written to the RTO,
they also taken
register. We have
Page
taken
73, your lordship can.
But at the end of the day,
with the MOD.
Huh?
MOD, Ministry of Road Transport and Highway Authority. They have to give us advisory because the vehicle is under blacklisted for other state. The MOD is the higher authority. They will give us advisory to the other RTO, the UP RTO, advisory to us also. How will we give this type of that? Because
why did you auction this vehicle in the first place?
we have not the forest person.
Acha, it was what, carrying what, timber or what?
I'm not aware.
Pangolin scales or what? What?
Completely
forest
order is there, but the page.
No, why? It must have been involved in some offense.
Okay.
Cannot be just confiscated like that.
They have approached us only for the
Who is
registration.
for the forest? Oh. Yeah. Okay. Yes, why did you confiscate?
Illegal firewood. Suspicion of
Firewood.
illegal firewood. Acacia. Cassette. Authorizing notice to further investigate.
Yes, Mr. Gupta, anything?
Your lordship will get page 58. Confiscation order.
Ah. Yes.
So they have to fill up one form, form 32. I have received the instruction. This is the process. Now, this is the instruction. There are two instructions. One is the letter dated 2nd January 2020. No, that provides for the standard operating procedure for the registration of vehicles purchased or acquired at public auction. HQ, मतलब, the second dated 2nd January 2020. But that lays down the procedure, the standard operating procedure. Not here, the person who has acquired the vehicle at the public auction conducted on behalf of the government shall make an application in the Vahan portal as per Form 32. Now, this is Form 32, मतलब, for change of ownership without submitting NOC. And step 2 is, person will book an appointment and pay fee as per Rule 81 of the Central Motor Vehicles Act 1989 and will upload the following documents. There are certain documents, which needs to be, attached in the online Vahan portal. And thereafter, the registering authority will take a decision, and after verifying, he registered the vehicle in the name of the person.
Now the problem is, if it's blacklisted, what decision will it take? Huh? It's hypothecated with the parent. If it's hypothecated, I don't think you can have a right over the vehicle. Then you pay back the money. Yes, madam.
It can be done within 10 days, 15 days, we are.
Not possible.
Not possible.
Not possible. Not possible.
It is hypothecated and it is confiscated.
You see, if it's hypothecated, then the first charge will go to the financial.
And not RTO, particular RTO has to be made a party.
Rajasthan RTO, he'll never come here. He's Rajasthan, it's not here. The blacklisting is in Rajasthan.
It is hypothetical. Yes.
Ministerial, nothing will happen.
And they have confiscated in the year 2019. And thereafter, auction.
But why is the financial party or not? Who is the financier? Who is that? Who was the one who provided the loan? No, but that organization entity could have branches all over India also.
Private person.
Private person, I doubt. Does that company know about this case? Because if the company knows about this case, then he can approach us, throw some light on what is to be done. That financier might be happy with the amount that he has given instead of getting zero.
Financier will not get any amount. If it is a confiscated amount,
No, the amount you paid in auction.
auction that is to the forest department.
Correct, the forest department will pay them.
I don't think so. Forest department it is retain the money to themselves. They will not pay it to them.
Because why should they make the loss of? They were the one who financed.
They would have to.
They were not the one who committed the crime.
They are not the ones. But when the vehicle was confiscated in the year 2019. And
Whatever, but the problem is that unless the
the money
person
has been
who
retained by the
financed it,
forest department.
unless the person who financed it knows about the fate of the vehicle, he doesn't know where it is. For all he knows, it might be in Africa also.
It is, your lordship will kindly see page 45, the details of the vehicle.
Anyway, no point. Where is Mr. Gogoi? Nothing. Oh, yeah, this is RR Gogoi. You are saying B Gogoi. Yes, what to do?
This is return of my prayer is there, I am also applied again for return of.
Yes,
amount.
Mr. Gogoi.
I am unable to use it.
Give back the money to him.
With
Give back the
50%.
money to him. At the end of the day, you have to pay.
I have paid prayer is to it, return the money with 15% interest. I keep the rate
Wait, how much interest?
15% interest. I've taken loans for the bank,
Oh, you're taking loan from the bank.
27 lakhs, some amount of money I have taken. That's small business, 27 lakhs, 12,000.
Interest portion, I don't know.
That your logical position. There are
Anyway, you are paying instructions, but at the, you see, there's one thing. That vehicle is financed by a certain entity. Now, those persons should be informed also regarding this. Yeah. Yes, they have to be informed. Yes, they have to be informed. They are having the first charge over the vehicle. You have got no right to do as you want.
timber was well found.
Maybe. But whether timber would justify confiscation of a vehicle, which is
No, that-
actually should be
that power
should be
is
with the
there.
financial.
Section 49 power is there. Power of section
No, no,
49.
maybe.
But other things.
But then the involvement of the owner also would have to be seen. Now the owner in this case is actually the financial, not the person whose name is there in the registration. Anyway, let's see. Next time, but what to do? What the instructions will you take? Whether you want to give back the money or not? That okay, right. Mr. R.R. Gogoi will approve instructions.
So when
As
the
to
money
whether,
gets paid,
huh?
when the money gets paid,
As to when the auction money submitted by the petitioner can be returned. Or if the same can be returned to the petitioner.
they pay GST, income tax, and all those things.
So the Mr. R.R. Gogoi shall also approve instructions as to whether the financier of the entity which financed the purchase of the vehicle has been informed of the confiscation and subsequent selling of the vehicles by way of auction. Now, keeping in view the fact that the transport authority in Rajasthan, has blacklisted the said vehicle.
And two vehicles. One other side, one Uttar Pradesh.
Both blacklisted both Rajasthan and Uttar Pradesh have blacklisted the vehicle.
Nine and three. Stop.
Mr. M.D. Bora appears for the transport department, while Mr. H. Gupta appears for 9 and 10. Section number 9 and 10. That's not give a date. When can you appear instructions? No point keeping it pending this
My
case.
lord.
So, he needs his money, that's all. Huh? Give a date. 15. You see, Mr. Gogoi, if you can file an affidavit, it is good. Mr.
I'm getting put a response.
Your name. P. Data. Appearing for all. All the, for your CGC also. The CGC.
And I'm
Appearing for all the respondents. Needs time to obtain instructions with regard to the grievance of the petitioner regarding cancellation of their license type as traffic porter, as what? As per porter. Porter who is the railway station, huh?
Traffic light.
As traffic license porter. Traffic license porter. PORTR. This is the matter after 2 weeks.
So, I'm staying on behalf of Mr. T. Sahul also. Matter में passport photo actually.
Who is okay, right? On the prayer for adjournment made on behalf of Mr. T. Sahul and pastor for the petition, and this is the matter after
Okay. Obliged.
Another blacklisting. They were supposed to file their affidavit, but they haven't filed it. We are awaiting instruction. In fact, my lord will peruse the last order. Your lordship was, I have allowed them enough time to file their affidavit, and interim was supposed to be considered.
Ah. Yes, lots of everything. The first, that was the first day of Mr. R. Gogoi, then counsel for the respondent. Praise for a last task to file affidavit and provision. Praise allowed, this is the matter after 3 weeks.
But your lordship may make that observation regarding the interim. Because on the next day, let the interim, if they, whether they file or not, at least the interim may be considered.
In the event the respondents do not file their affidavit by the next date, the prayer for an interim order may be considered.
Right, okay.
I took 25. We have not received, I'm referring for 20. But madam, I have seen the documents, madam, the bill, purchase and payroll bill receipt. Without name, without address, without booking. All the bills are.
But all are
So whatever you have stated,
The
let-
tomography,
let the client see that.
large. Address.
It might be written in invisible ink only known to the authorities there.
Very clear, madam. No name, no GSTN number, all the, madam.
Correct, you were not
all
careful.
the bills were certified by the ADC, my lord.
Madam,
Lordship will
certified,
consider.
but no,
All the bills were
I
certified.
found it, madam, strange, madam, because the lordship is very.
Let them file the affidavit, my lord.
I'm fine, but madam,
But-
okay, without name, madam.
Without any name, why the ADC has certified, my lord? That is the trust question here.
Lordship,
If
They-
they are
they-
raising, if they are raising it, my lord.
Because maybe you have given him some private supply also.
No, my lord. There is not.
as madam.
Oh wow, some rasgulla and whatnot.
Just I have to go, after going through the papers, madam, I have found it.
I know. What to do?
Lordship, forest, everything.
Okay, right, Miss Yudas, Learned Counsel for the foreign number.
2 and 3.
Is granted 3 weeks time to file affidavit. This is the matter.
Not of the
Apply. Yes, please, Lordship. Lordship, can you pass over the message for 10?
Here, I have an instruction, lordship.
Yes,
That interestingly, lordship will be clear, if I call lordship goes.
the whole thing.
There is a new development, lordship. Actually, there is a title book where we have one. Where is the title, learned civil charges.
Then why is the affidavit silent?
Yes, affidavit we have not filed. Actually,
Okay, you have won a title suit against two,
against
all these persons.
all these, not this person, actually they have not,
They are the purchasers, eventual purchasers.
yes, from the original Pakada, name should be deleted. There is an order from the lower court. We have, where we have one in the month of March this year. Where the learned civil judge will just find that in the backdrop of discussion and observation made above, the mutation of names of principal defendant, that is Viveka Datta, is the original, whose name is being inserted in the appeals of the AFC lordship, and others in respect to Medavi is illegal and liable to be cancelled. Accordingly, it is decided in fact, we have won the case in the civil court. This part actually is decision.
This, what about in the affidavit? Has not been mentioned.
So it is the government has filed the affidavit. I have not filed the affidavit. I have.
So government does not know about this. Mr. Nasir, 2009 report. Why are you relying upon a 2009 report when this writ petition is of 2021? Everyone is looking forward to what can be done after, as per what new models of computers will come, and you're going back to the Bullock age. Yes. Anyway, what to do?
Very interesting.
When is the senior?
He's in left club.
Very interestingly, Lord,
Only
here
part
Lord,
of the
that
report
British someone is very categorically has not made party the the original landowner. Whose name is reflected in the revenue record. And against whom we have owned the case in the title suit, Lord. And against whom the title suit was pending since 2012, Lord.
Anyway, we'll respect everything.
Interestingly, Lord, we clear, Lord, even the position certificate was handed over to private government. Lord, it's entirely good.
Passport what timing?
I agree, Lordship. Actually, that day I was about to complete the by the government.
Yes, you have considered it.
Lord, it could have been a very
Big,
big
colossal blunder by you.
blunder by me, my God. But if the officer has given me this blunder. In 1994, I was here 75 because it's award. I was supposed to give that. That's it. That's a great blunder.
You would have to. We would not have seen you as a council anymore for AFDC.
No, Lord, if they know me, it was not. I will find a review. It is actually exercise.
Anyway, I think you file an affidavit. No point waiting for your finish. Otherwise, we'll hear you argue. Correct. Mr. P. Sharma, Learned Counsel for the AFDC, submit that the here you are here. You have lost the case before the civil judge Karimganj.
One case was pending, man.
It has gone against you.
It took March.
March 20, 2024, last month.
So, Manoj, I will take the exception. That covered it. Take on.
Huh?
Ask the case. No, Manoj, I have no information.
I think you'll have to withdraw this research.
So let me
Other
take the exception matter. I will go for
Take it back. And the property also has already been handed over.
Earlier, my lord, earlier, one title suit was there. Thereafter, there is a appeal, my lord. Appeal was lost by them, my lord.
I know that they lost that appeal.
Yes, ma'am. So it was finality, ma'am.
Now again this order is there.
So subsequent order is in favor of me on a this matter.
In favor of myself. In favor of our safety.
Last court date you were winning.
Last court, I was able to concede.
Yes, now he's winning. Last court date you were smiling, now he's smiling.
But it happened.
Yes. Okay, right.
So I will
Mr. P. Sharma, Learned Counsel for the petitioner, submit that in terms of title suit number 140 of 2012, which was disposed of on 20/03/2024 by the civil judge number 1 Karimganj, the property in question is declared in favor of the AFDC. The petitioner's counsel, Mr. A.K. Azad. Huh? Duty. Submit that. Praise for time to obtain instruction. Praise allowed. List the matter on next Thursday. Next Thursday.
My name is P. Sharma.
Okay, for the AFDC. So you give him a copy of this or sir? You can take this back.
I'm giving the order, not the instruction.
No, not that. Only the order. You can take this back.
No, not big order.
Not at all.
Take it back.
Okay, very good.
Take it back. Oblige. Sometimes giving consent is skill.
Huh?
Sometimes giving consent is helping in skill.
300 acres of land. But
Anyway, let him obtain success. Let us see, he might bring some other judgment also. But
earlier, but appeal also. I think
I don't know.
now, but maybe man, some question or some question may be there, man. But what question I will take, man. Of like,
Maybe better to go in execution before the concerned court, not here. If there are so many different orders, or you go in a first appeal, a second appeal.
earlier, man, one round one.
Yes, now
This High Court also passed some order, man.
There is a very technical, step now, in spite of knowing that we have taken possession in 1994, they have not made us party. And they have, even the civil judge also handed over park order. Everybody was passing order, but without making us party. We came to know in 2011, 12. Immediately we filed that case.
And the deputy commissioner also filed a letter, man, submitted letter 2017 matter, stating this in favor of the petitioner. Now the turn is free.
I don't know, next court date, you might be laughing again, he might be with a sad face, we don't know.
They filed the affidavit.
They filed the affidavit of
Record, not your fault for the.
So what to do?
as per affidavit lordship, they are yet to pay 7,92,000 for this. They have not yet paid.
According, have they admitted that amount? How they have
Yes,
admitted?
there are five.
There are five. So you pay this amount?
Not make it expensive.
No, no.
Have to.
No, you file contempt. You cannot keep it pending. You'll have to file contempt. You have to file. Unless you follow all the procedure, they will not pay you. If we keep it pending here, they will not pay you.
That with some insurance process. It's 2018.
But you also came in 2022.
But several representatives have filed with the consider that report.
Beyond period of limitation, madam, you have come beyond limitation period. Right. Third is, R. Chaudhary, Nanak counsel for the petitioner. To submit that the petitioner's vehicle bearing registration number AS02Q 1462 has been hired by the district administration Hojai for official use of the Hojai police station from 1/3/2016 to 2/5/2018. So the petitioner submitted his bill. No, the petitioner thereafter submitted his bill amounting to rupees 8,61,654. While rupees 1,43,934 had been paid to the petitioner. The balance amount of rupees 7,17,720 has not been paid.
Report that they are giving. And as per their calculations, I have received more than what I have received.
Then we have
Maybe there is some miscalculation lordship, and what they are saying I have received 153, but as per my calculation, 143. As they are already admitted with all documents. So they are
That is lordship, her claim was 7,17,000, we are paying in 7 lakh. That is the.
Okay, you don't say the amount, huh? Whatever said, while the petitioner, no. submitted the bill for the vehicle hire charge. While a small amount of money has been given to the petitioner, the major portion of the bill had not been given to the petitioner. Next slide. The petitioner also submits that in terms of para five and para 5 and 6 of the affidavit in opposition filed by the superintendent of police, Hojai district, Assam. The respondents have admitted that they are liable to pay the petitioner rupees 7,92,04. Accordingly, a direction may be issued for payment of the admitted amount. Next slide. Mr. S. N. Roy, the response for the respondent topic. As the petitioner is to be paid the admitted amount provided in the affidavit of position. Some time may be given for payment of. I have heard the learned for this. A perusal of the affidavit in the position filed by the respondent number 5 shows that the petitioners have admitted that the petitioner is liable to be paid rupees 7,92,04. Para 5, 6, and 7 of the affidavit filed by the respondent number 5 is reproduced herein below as follows. The in view of the above fact, the in view of the above fact, the respondents are directed to pay the admitted amount to the petitioner within a period of. So since now election is going expected after 1 month is too good. 3 months. Within a period of 3 months from the date of receipt of a copy. This petition is accordingly.
So if your lordship direct, the response of 5 pages. In the para 8 also they have,
Okay, make it according to the respondent number 5, no, you will pay the amount. Within period of 3 months from the date of receipt of a copy. This petition is accordingly.
it's okay.
Actually, that Ms. Chaudhary, what you are thinking? Wait, actually, it should be re-verified once for the amount payable. Otherwise, it will not be proper. हाँ, अच्छा sanction amount. So that has been a proper calculation. Is it? But you see, the claim, there should be a re-verification. Verify and pay. I think that's better. Otherwise, it will not be proper. Just give me that.
I thought that,
Which one?
but,
Huh?
supplementary for the
This item? No, we are disposing it. I'm disposing it as is. It doesn't matter whether it's at 2 or 3. It's admitted amount, no doubt. But then the thing is that Re-verify. So what do I say you see? Amounting to rupees 8,61,656. Out of which rupees 1,43,934 as was paid to the petitioner on March 2020. However, the balance amount of rupees 7,17,720 has not been paid to the petitioner. Okay. Next, what is next? Next, please. As the admitted amount, the submit that I am the petitioner is to be paid the admitted amount. The admitted amount can be paid. I have heard the last part for the party. Uh, a perusal of the reading show that while the petitioner has made a claim for payment of outstanding liabilities of rupees 7,17,720, the required number 5 has stated that rupees 7,92,04 is payable to the petitioner. Right. Next para. It is clear that as there is admitted liability payable to the petitioner, the petitioner would have to be paid the dues that are payable to the petitioner. So the problem arises with the amount to be paid to the petitioner, keeping into the fact that while the petitioner has claimed payment of rupees 7,17,720, the required number 5 has admitted that has stated that the petitioner is liable to be paid rupees 7,92,0. Next one. Para 5, 6, and 7 of the affidavit of provision by the respondent of 5, 6, and 7. Next. In view of the discrepancy in the amount of payment to be made to the petitioner, the respondent number 5 is directed to make a re-verification of the amount payable to the petitioner and pay the re-verified amount to the petitioner within a period of 3 months from the date of receipt of a copy of the fund. The rich petition the following day. That's better. Look. You please tell her. Is it written somewhere that sanction has been already given? Huh? Where the sanction is given or not? That's why I'm checking also that the given for sanction but not given. Okay. Next item.
Not for the creditor,
Huh?
not for the responsible for starting to fight.
Which one does it pass? What I can pass. That
But they identify that they can, that is, what,
Certified medical class to case with the side of this order if I did not.
When is the ECF letter? 18/3/2024. How does it matter, madam? In the contempt, then instead of the word may add this character. The contempt case, let us see what is the order of the court. What's the order of the I had asked you to, this court had asked you to peruse the same and make a submission. Have you perused?
They were starting to bring the case report on.
No, that is a separate thing. That is only for the purpose, because in the meantime you asked, you said that you had not seen it. So you are asked to peruse the document. If you're not perusing it, then I would dispose it of as I see fit. You had 1 month time to go through the document. Basically, whether this document has been made in compliance with the order. That's all. Has it been made in compliance with the order?
Because they should submit a, they submit the report to the
Regarding the completed inquiry. And pursuant to the inquiry, if it is found that the money was payable to the
Correct.
there is missing.
Correct.
So that inquiry was never conducted.
No, let us see the speaking order.
Now,
What order is it?
this speaking order has come from certain authorities who are not parties before the proceeding there. They have come only because there was change in the office of the incumbent and applications were moved to bring them part.
What are the, let us see what the speaking order
Now
says.
they say in the speaking order, they refer to certain inquiries committed pursuant to a division bench judgment of the honorable court. Now in that division bench judgment, the responsibilities were ultimately fixed on the Department of Opinion, not on the petitioner before your lord. Now, unless and until, since your lordship has also observed in the last order that this should be brought on record by way of an affidavit. Now, unless and until this comes on record, I do not get a chance to place my content.
No, you can go through it now. This is between the court and the contemptor, not, you have got nothing to do with. The contempt case, you have got nothing to do with it. You're only supposed to bring it to the notice of the court. It is not a case where
Now,
you
if-
can argue as you like. It's
No,
not
now,
that.
the contentions that they have now raised, they run absolutely in contradiction to what they have stated before the honorable.
So what does it say? That's
Your
what I'm asking you.
Your lordship, just a minute, Lord, I'm just bringing to your lordship notice the affidavit that they have filed. Then the contradictions will appear very apparent. Your lordship will kindly come to page 31. That is the affidavit in opposition they had filed in the proceedings for the
Page
before
31.
the court. 31, and the relevant part will be at page 35. 35, paragraph 10.
Yes.
Page 35, your lordship, paragraph 10. On 27th March 2024, the predecessor in office of the deponent again got the inquiry report of the inspection and quality control team submitted before the government, and by later dated so and so the same was given to the deponent for taking necessary steps. Having received the same, the deponent as Chief Engineer Irrigation Assam so and so issues instructions for a fresh inquiry into the matter. Accordingly, committee headed by additional chief engineer conducted an investigation and of so and so recommended for payment of outstanding bill of 1 crore 87 lakhs 64,369 due to the petitioner by submitting a fresh report. So that was the recommendation that was available on the file. Now in the inquiry, in the so-called speaking order, my lord, they want to start off their responsibility by saying that as if nothing is due to them. So therefore, unless and until this is brought on record, my lord, these factual contradictions I cannot draw.
You find this, sir?
The last contempt order was part of my speaking order. We did that. Like if the agree file direct from file is challenging this order at all. If you understand which is a subject,
File an affidavit.
very well noted.
You just filed this affidavit, and you also filed that letter dated 18/3/2024. That is mentioned in the last one.
Okay, very well.
Right, Mr. R.R. Gogoi is granted 2 weeks time to file affidavit in terms of the other dated 28/3/24. This is a matter of.
Okay, okay.
Yes,
In this matter, the petitioner is for revision of this matter. It's a profession of order.
what is the law?
There's nothing about revision or justice of. First of all, he called for extension and document it was rejected by the honorable court. Thereafter, it was given a record due to my interpretation for remission of its this month. We made a representative for a year, but the competent authority is grant this remission of the piece. They go before the piece here. He said, you can go for this, but take up. But the statute doesn't provide for any remission.
Right, no one appears on behalf of the petitioner. This is a matter of.
Okay.
What is your claim?
Here might not, I entitled on the 4 lakh.
4 lakh. How much are you admitting?
Entire body is admitting, but the affidavit has been filed.
Huh?
Affidavit has been filed in 1/8/2023. But the earlier principal secretary he is already stated in the affidavit that on the date of filing the affidavit, he is not the principal secretary. And it is
He is claiming rupees 4 lakh. Correct. And what have you stated that he is entitled to 4 lakhs or not?
4 lakh.
Huh?
That will be it's a very good point.
Paragraph 5 of their affidavit.
You come to paragraph 5 of your affidavit. See how much you have admitted.
Yes, but
yes.
so that's the purpose of
Huh?
purpose of it. That's why I got a stop.
So you made a correction.
In that fact, my lord, so this person is not the petition, not the secretary as on date. And yet on the date of finding the affidavit, he also not the secretary. This
But whatever the fact you made, you made a correction because out here you have admitted that the petitioner is entitled to 40 lakhs, while he's claiming only 4 lakhs. Also, government of Assam now they give it correct.
I have to admit, my petition.
But the other case also, they are admitting to more than what was claimed.
That was the thing, my lord. In the meantime,
Typographical error.
you ought
In words also,
what was
it is
the
40 lakhs.
They're supposed to populate this honorable court order by.
Huh?
They're supposed to populate like this.
So the 40, you pay, it's a contempt.
Fine.
I'm not going to pass any, direction in the contempt, you cannot pass. That is already passed in the next petition. Only thing is now, if you have got to pay the amount, so you pay the 4 lakhs, where are you paying?
posted after 2 weeks, but in the meantime, with so the new Center Secretary to be released.
The council, 2 weeks, the always continue 2 weeks. This affidavit is filed in August 23. How many 2 weeks have passed since then? At least 32 weeks. What's the lot of things that have been diverted? Right. The prefecture. No, the prediction was found entitled to be paid rupees 40 lakhs. No, 4 lakhs. 4 lakhs. By order dated 10 to 2022 past the WPC 786 2020. However, the affidavit in the position filed by the respondent has admitted that the petitioner is entitled to payment of rupees 40 lakhs. Mr. L. Bora, appearing for the sole respondent, submit that there has been a typographical error in the affidavit supposition. Accordingly, the said 40 lakhs reflected therein has to be read as 4 lakhs. He submits that he will get positive instructions within 2 weeks with regard to payment of the same to the petition. This is the matter of the 2 weeks. Of the immediate benefit. Small investment. It is the Here,
Let's say that the first proposal on 7 was released.
first proposal to whom?
Chief engineer,
To?
exponent number 2.
A fresh proposal has been sent by whom to whom?
Right.
To? Which department?
WD.
For payment of the amount. Okay, what is your name? Your name, madam?
Oh, Asmi,
Oh, Asumi,
on behalf of Dina.
appearing on behalf of Mr. Dina, submit that a proposal has been sent by the executive engineer, PWD Road, to the chief engineer for payment of the estimated amount of rupees how much?
30 lakhs, 18,700.
30,18,75. The council shall obtain instructions with regard to the status of the proposal sent by the next day. This is the matter after 2 weeks.
Let it be up.
3 weeks.
No, directive. I had a report. Well, I undertake, I had a discussion with the secretary and the officer concerned. They are expeditiously following it. And seeking some, there's a little time. This is the short span of time to comply with. How short, the funds are being asked for, that means that 15 days time may be given. But the finance department has been moved, budget, there will be a back budget.
This instruction is received from whom?
Or you keep engineer.
To what effect?
That we have asked, submitted supplementary demand, supplementary budget demand to meet this extent.
Show me the forwarding letter.
How this is done. It is for 23, and the department, I had a discussion about 4, madam.
23.
That is 20. But individual can I know?
What is this date? Can't see the date.
It's over
23. Mr.
Yes.
Council, can a supplementary demand that was submitted for the financial year 23-24 be considered when a new financial year has come into effect?
but that demand is still pending, madam. So we have,
Mr. Council, let us not. Well, I understand, but it's going to go big, 15 days is that, it's big. Nothing more to say. But we are taking, got your, no, fine. Money crunch is not the issue. The issue right now is whether you're trying to take this sport for a dive. No. That is the reason I'm on the. Right. Otherwise, on the many things to say, how did work, what are the objects, who works without budget, they sign that they will be. No, those are different issues. What happens is money lapses due to at the end of a financial year. A new budget is prepared. A new proposal has to be made, a new sanction has to be. Now, when you come up with with the structures, that proposal has been set in the year 2023. That has nothing to do with disbursement of money from the budget of 2024-25. This is playing around with it, my lord. Well, 15 days. Right. This thought, right, order dated 1/4/2024. I directed the chief engineer PA to give an up-to-date status report with regards to the supplementary demand made for payment of rupees 48,63,97 from the finance department. From the budget for the financial year 2023-7. It's a big over. Big over. Has submitted a letter dated. What is the date? That's down to the. It's just signature level is not clear. They can overlap by that signature. Submitted a letter dated packet, national packet, word, unreadable. Which shows that has been issued in the year 2020. This court is unable to understand as to how a supplementary demand made in the year 2020 would be approved. The supplementary demand made from the budget for the year 2023-24 could be approved when the new financial year 2024 that 25 has come into it. These are the mistakes. Mr. D. Gogo is subject. Something will come out of it within the next 15 days. 14 days, this is not after 15. It's only the same amount is. Amount is. Okay, I'll say what is the amount? It's 17,63,000, 363. Hold it.
I wanted 4 times to check my expenses.
For who?
I'm for the department of. number 1, 2, 3, and 4.
This is very simple. We don't even need affidavit. As on, it. We only want, this court only wants to know whether any photograph has been mixed along with the justification report made by the respondent. You can always call them up by phone and say whether it's there or not. That's it. That will clarify the entire issue. Because both of you, or both of them, I think you all have quoted below the estimated amount. Correct? And that has to be justified. The justification requires photographs to be made. So they are saying that there is no photograph along with the justification. That's all. What affidavit you want to find? You just bring the report showing the justification report submitted by the respondent number 5 and whether the same contains the photograph. That's all. You bring the file. You bring the concern tender document of the respondent number 5. That's all. Okay. All right. This submit that on the next day. He will produce the justification report submitted by the respondent number 5 along with the photograph to be submitted by the respondent number 5 along with the tender, along with the justification. This is the matter on. What is it? Next, you said next, when do you want it? Today is what day? Please, 26. This is the matter on first.
Okay, wait a bit.
Huh?
I have some problem.
Second?
Please,
Second.
second, I have some problem. No, no. Please, second, I have.
Right? First.
Okay.
Waiting for F1 number 2 and 3, we have filed our reply to the affidavit.
Huh?
We have filed a reply.
Okay, you have filed a reply, you are, okay, you are opposition.
Yes.
And my lord, so far, office to this is 23 for 24. Service upon respondent number 4, that is perfect. As per the offense. This. Okay. So what is to be done?
I need to file a reply to the benefit in opposition
File,
filed
file.
by respondent number 20.
Good. And you are filing any affidavit? No affidavit. At first, are you filing, I said?
For 15th time may be accommodated.
How much time do you want?
3 more.
Huh?
There is a interim order. If I have already filed my. So they have waited within 2 weeks, the biddings will be complete. They may exchange the bidding within 2 weeks. So there is nothing I can show you what with the interim order will be taken. I have not filed any stay vacating petition.
So at least because he is also going to file.
No, Mr. Kaushal, you will take it 2 weeks, and then if he has filed it by then you file your, it might not be required to file any reply. We'll see. Let's finish up. Mr. D. Bora, Sir, counsel for the petition is granted 2 weeks time to file affidavit opposition, affidavit in reply to the affidavit opposition filed by the respondent number 2. So on the other hand, Mr. P.K. Gogoi appearing on behalf of the respondent number 4 is granted 2 weeks time to file affidavit in opposition. This is the matter after 2 weeks.
Yes.
Like solid. I'll be waiting for the respondents,
You'll be appearing for
the respondent.
all.
Wakalatnama has been received, but the seal has not, it's not there, so
Are you filing any affidavit?
we'll be filing.
Mr.
RJ Tar.
After that, submit that he will be filing Wakalatnama on behalf of all the respondents. Within a week.
1 week,
Within a week, and affidavit of position within
3 weeks,
3 weeks.
2 weeks, maybe.
Within 2
2 weeks.
weeks.
There's an interim order.
Within 2 weeks. This is the matter. This is the matter of the 2 weeks. Interim order to continue till the next.
Similar. Similar.
Where is your, in the next one, what is your affidavit of service? That's the first two. There's no affidavit of service.
File yesterday, Lord.
But anyway, he's
We are
appealing for.
appealing, so that's deeply.
And you did not take step first.
No, Lordship, I have taken a step.
Register post it dating with the second one. The
No,
first one
Lordship,
you took.
Lordship, record is there, Lordship. Record is my hand, Lordship. I have taken a
We have
step by.
received registered proof.
No, no,
Register
no,
for
that
as
is
well
the
as that's the
office
Lordship.
note. Office note is not correct.
Yes, the office not reflected, Lordship, but I have taken steps.
Okay.
Both of the cases.
It's a fine. हाँ covered matter covered.
And now let the package number is
But since you asked for adjournment, we will allow it. You asked for adjournment. We will allow it. What is it? What is the case, madam?
regarding the non-payment of contractor's fee.
No, non-payment of contractual fee. For what? For what contract?
Cleaning. Page 106. Cleaning, distancing, and maintenance of cleaning, distancing, and maintenance of all city drains into ICC for the year 2020 and 2021.
NIT dated? Tender notice dated? Page 30? 34, 28, 1. Okay, right. Third, Miss
As per
Bennett counsel for the petitioner. Submit that the respondent number 3 had published an invitation for bids dated invitation for bids bracket IFB dated 28/1/2021 for cleaning, desilting and maintenance of all city drains in Guwahati city for the year 2020-2020. The petitioner's bid was accepted in in relation to package number C and D /47. And the petitioner was issued a letter of acceptance by the respondent number 6 and a notice to proceed with the work. After furnishing the requisite performance security and signing of the contract. After the petitioner started executing the work as per the program, the petitioner was served with a show cause notice dated 8/6/2021, issued by the respondent number 6, to which the petitioner submitted his reply on 10/6/2021. However, the petitioner was served with a termination notice issued by the respondent number 6 on 12/6/2021, terminating the work order dated 11/5/2021, made against package number CND slash 47 with immediate effect. The petitioner, the petitioner's counsel submits that the petitioner should be given payment for the work done by the petition after verification. He submits that a series of writ petitions filed by different contractors before this court has been disposed of by its order dated 20/12/2020. In the leading case, the leading case being WPC 3164 of 2021. Wherein the GMC and GDD have been directed to undertake a verification exercise, including measurement of work done for payment. It submits that a similar direction may be passed in this case. Next, Mr. S. Bora, appearing for GMC and GDD. Is it? Appearing for the GMC. Appearing for the C.
The GMC.
Huh?
For no one is the CPC rate now. All the
Appearing for all the respondents submits that the present case can be disposed of in terms of the order dated 20/12/2022 passed in WPC 3164 of
that is not what you can't to pay number per packet. That will that will have to be absolutely remeasure it of all the drains that has already been done. Thereafter, what will get the lottery order on page number 20 on 20 that will otherwise we will not be able to measure it.
Okay.
Whatever it is done,
In terms
first
of
will-
the, you don't use the other cases. In terms of the order dated 20/03/24, passed in WPC 1622/2020.
detail order has been passed. Also measure.
Huh?
Detail order, not to pass a detail order.
Uh-huh.
All the
Yes.
here there has been monsoon and then we cannot measure it again. We'll have to verify and only then we can only whatever they are.
Where is the terminating order, termination of page?
Is 110.
Huh?
110.
I've heard a left off for the termination notice dated 12/6/2021. States that the executed quantity of work undertaken by the petitioner till 12/6/2021 would be measured within a short notice by the concerned divisional engineer in the presence of third-party monitoring agency engaged by this GM. In that view of the matter, this court is of the view that the petitioner should be paid for the amount of work executed by him, as measured by the respondent in terms of the letter dated 12/6/2021, issued by the respondent number 6. accordingly. Next, I have also seen the order dated 20/03/24 passed in WPC 1622/2020. And I find that the present case is covered by the said order. Accordingly, this petition is disposed of in line with the order dated 20/03/24 passed in WPC 1622/2020. Paragraph number 150 was stated. Accordingly, this court directs the respondent, more particularly the respondent number 3, to pay to the petitioner the executed quantity of work done, as measured by the concerned divisional engineer, in presence of a third party monitoring and in agency engaged by the GMC in terms of the letter dated 12/6/2021. The entire exercise should be concluded and payment made to the petitioner for the work done by him, within a period of 6 months from the date of receipt of a certified copy of the fund. The writ petition is accordingly disposed. 127. This is true. One more matter there. Yes, yes. That's why I think we should move on. Then we will keep it. So you will be having some other work at 2 o'clock probably. Yes. What is this matter? Yes, lovely. Yes, sir.
Background of the case here, okay.
Yes, sir.
Yes, yes. The petition for your lordship is an administrator of a key estate called Fatima Bar, which is situated at Boxa BTC area. The custodian of the tea garden at Boxa here. But there are certain issues
The custodian
is Forbidden Park. There were certain disputes which were there with the previous owners in regards to period. Proceedings are on in that regard. I am only the administrator who is now presently running it since 2021 by an agreement that has been executed for Forbidden Park. On second of month, in the month of February 2024, certain workers of the team walked into the garden. They made certain illegal things. I said the demands cannot be made. I reported the incident, saying that there is a violation because they said that they'll call for a strike if it is not. I intimated the administration and also put a letter to
administration meaning the district administration.
district magistrate and to inform that this is the situation which is arisen. And I also wrote a letter to the council, to the conciliation labor officer, town conciliation officer, intimating that there is an uprise or an incident that can happen to other management in this and ask for a conciliation. In terms of that, your lordship, two conciliation proceedings took place. One was on 22nd, one was on 29th. Unfortunately, of February 2024. Unfortunately, both the conciliations failed, and there is an order to say that there were certain demands that were made, which cannot have been settled at that point of time within that short time of time in conciliation. Subsequent to that, your lordship, these incidents were implemented again to the district and the state authority. The state authorities go to the workers and said, let us settle this matter immediately. These are relating to certain views of the previous matter. which will have to be looked after by the competent authority, which is here, which is already has issued certain proceedings pending before that. And subsequently, they have now said that we will settle this issue with both parties coming down to settle anything. Subsequent to your logics, again on 2nd of April, when these things were going on, another group of people entered the tea garden, out the office, and said that no work will carry on, and we are now going to have what we call a strike in terms of the work that was going on. We immediately intimated to the administration. Administration said no. We also wrote a letter to the conciliation officer saying that in the previous round this has happened. This is again as the situation is written. And another conciliation was to be proposed on 18th when the strike was going on because they refused to work for 4 days. Subsequently, the strike was taken out and they got back to work, but they were on a go slow motion. And lockout order was passed by the tea garden saying that this is not possible to work under circumstances. There is already an unrest. We are not able to handle this situation because they've been threatening us. They're not able to work. And a lockout order is passed. When this order is passed on 18th, that's the order on page 66. So the dispute, the main reason I'm here starts because of this order. Page 66. Yeah. I just read it. This is not a very long order. This is to bring to your knowledge all the concerns of Fatimabad Tea Estate, including workers, sub-staff, staff members, that after an unauthorized absence from duties of all the workers from 2nd to 6th, the garden reopened on the 8th of April, but the workers have deliberately worked till 2:30 p.m. instead of 4:30, resulting in huge loss to the garden, and due to which we have behind more than 20 round days with long leaves, tea leaves, because of go-slow practices, which badly impacted the outcome of the talks. Again, today at 12 noon, some of the workers, sub-staff and staff members, without prior information, and have unauthorizedly eroded our company's executive at the factory office premises and arrested unnecessarily, for where the police have to rescue him. But the entire area of the garden is under 144 SME, and the ground in the garden has been restricted by the district magistrate Boxer, so and so. But till now, no concrete action has been taken by the police or the administration from 16/3/24. We are not going proper protection to run the garden, for which loss has been incurred by the garden and its management, despite that we have cleared all our wages, rations, etc. on time till 13/4/2024, and managed the things with the thought of normalcy will resume. But today's incident has put us in an insecurity of our executive, and in this scenario, how long the purpose of the company as normal works is not being done by the workers for greater into the garden and its workers. This paragraph is important. By going through all the above, the company has decided from tomorrow, that is 19/4, there will be no plucking and no any other garden work till the matters is resolved and necessary actions taken for today's incident for the safeguard and safety of our executive. However, the workers who are at the work in the factory will continue their work till the completion of today's leaf manufacturing, then the garden will be declared as lockout till the resolution of the matter with the help of administration. So this was the order that was passed in terms of the incidents that happened prior to this. Subsequent to this was intimated, and the Labour Commissioner at page 68 had issued a notice. This is and initiated a conciliation proceeding on 19th of April 2022. This letter is at page 68 of it. And said both management as well as the workers to be present. Whereas an industrial dispute arises between the management of Fatimabad Tea Estate and their workmen represented by ACMS under the issues noted below, and whereas it is expedite to take up the matter under the provisions of the industrial dispute, I so and so, whether being considered an officer under Section 4 of the Act, to hereby fix it for 22nd of April at 12:30. This conciliation proceedings happened, your lordships, subsequently. And at page 75, that's the order which is passed after the conciliation that was passed. Annex 16, page 75. Page 75, Annex 16. These are the minutes.
I think it'll take some time. Reading itself.
One more additional.
We can pick it up at 2.
Yes.
So, I think it's paper. That's very short. It's 3-page document.
Ôi chào quý vị.
This petition is
Small recap.
Huh?
Just a small recap. 21, as an administrator, I was given the tea garden to run.
21.
21, year 2021, I was given the tea garden to run. The first problem started in February 2024. Subsequently, 2 configuration proceedings failed. The problem sustained. Then the second round started. When they again in the month of April, the similar problem started. Now, in terms of that problem, section 144 was invoked because things were out of control. Subsequently, the lockout order was passed by the management. That I read it to about some time back. Subsequent to the lockout,
Lockout order page.
yes, 66.
That-
Subsequent, the conciliation officer had issued a notice asking the management and the workers to come forward for a conciliation. I'll be reading the order. That notice your lordship is at page 68. And the order passed is at page 75 and extra 60. I come to the relevant part at page 76, your lordship. At the bottom, view of the configuration office. From the prolonged discussion with the ATPF of the constituents, workers, labor, staff, sub-staff, secretary, ACKS, Fatimabad Garden Unit, and the president, DCMS, primary committee so-and-so, has been clear that all of them want to resolve all the problems of the estate. The secretary so-and-so has raised some legitimate demands in respect of the staff of the TSD in the conciliation party, which have been reviewed thoroughly and found that a huge sum of money of the staff under different heads are still pending with the present management of the TSD. The president so-and-so also has placed some legitimate demands in respect of the staff and workers, laborers of TSD in the conciliation party, which have also been reviewed thoroughly and found that a huge sum of sub-staff and laborers under different heads are still lying pending at the end of the present management of the TSA. These issues problems are very difficult to be resolved immediately through a mutual understanding between the stakeholders at this end, because the workers / staff are very much unhappy with the administration of the TSA. The district administration took much needed initiative to properly address the tea garden issue and organize a large meeting on so-and-so in the conference hall. In the meeting, the Honorable District Magistrate Commissioner, Madam, listened attentively to every speech and demand. After she said all the issues can be resolved surely, and it requires a joint effort of all the stakeholders. She requested everyone to give the time till the ensuing election process is over, and till then let the tea garden run smoothly without any disturbance. Now the relevant part, Your Lordship, the next paragraph. But few days after the meeting, the tea estate became turbulent again. And in view of the lockout that was started on 19/4/2024, that is why conciliation was organized today in this office, and all the authorized representatives of the management staff workers of the tea estate. But this conciliation could not accomplish fruitful, because the very beginning of the discussion, quarrel started between the workers, staff, and the administrator, and he left the meeting, giving repeatedly request of myself. Rupari PF officer. Thus, the situation gradually heated up and went out of control. After observing the large contingent of the agri workers at the tea estate, it would be advisable, considering the law and order and security concerns, all the workers and staff want the present administrator to be removed by any means, and this tea estate should be handed over to the previous owner.
The thing is the whole time, okay,
All the workers, staff and sub-staff want the present administrator to be removed by any means, and this tea estate should be handed over to the previous owner. Only then will complete the peace and order be restored. They were all chanting, Jalan, go back. That is the petitioner who was running the administration. Is in a very loud voice, and for which the atmosphere around the office became very hot and tense. Apart from me, the ALC Rupari, who is Assistant Labour Commissioner, Rupari, the PF official present in the conciliation were very scared for the safety of Mr. Jalan and the administration of the tea estate, because heated words were exchanged between the workers and the administration, and due to which the accident could happen at any moment. However, the police arrived in time and took him over. So the conciliation that happened on this day also failed. Subsequent to this year, that is on the same day when they conciliated failed, on the next page, your lordship, at page 79, is the interim order that I agreed. That order is passed on the same day, which is 22nd of April, by the labor officer cum conciliation officer, which says revocation of the lockout at Fatemabad Tea Estate. This is to notify the management of Fatemabad Tea Estate that, as per legal directive and instruction provided by relevant authority, the lockout was declared by the management of the tea is to be immediately revoked. And then, your lordship, it says the lockout was declared without proper justification or to adhere to a legal procedure. There was a civil suit which was filed, your lordship, in regards to the auction process, which is still pending. The second one, the authority has explicitly instructed the management of the tea estate to revoke the lockout in accordance with their letter dated so and so, wherein the custodian of the tea estate, which is the provident fund, they have clearly mentioned that the management of so and so have declared the lockout without prior approval from them. Number two, therefore, the management of Fatemabad Tea Estate is hereby directed to revoke the lockout immediately and allow the resumption of normal operations of the tea estate. This order was passed on 22nd. The reason I am here is, with all due respect, this order was passed in a completely erroneous manner, because there is no jurisdiction for the conciliation officer to pass this order. At the best, if the conciliation had failed, they could have put up to the authorities, and the authorities would have taken the subject matter and taken a call. This is because of Section 12 of the Industry Act. I've already mentioned it in the petition, the limited role that the conciliation officer plays in this kind of circumstance. Before that, I just read Section 4, the appointment of the under the Act of the conciliation officer. May I just read it? 4. The appropriate government, by notification in an official gazette, appoints such number of persons as it thinks fit to be conciliation officers, charged with the duty of mediating it in and promoting the settlement of an industrial dispute. Number 2, the conciliation officer may be appointed for a specified period for a specified industry in specified area, or for one or more specified industry, and either permanently or for a limited period. So this is how the conciliation officer is appointed by Section 4. Now, your lordship, if you kind enough to come to 12. The duties of the conciliation officer. May I read?
Yes.
Yes. Where any industrial dispute exists or is apprehended, the conciliation officer may, or where the dispute relates to public utility, services, and a notice under Section 22 has been given, shall hold conciliation proceedings in the prescribed manner. 2, conciliation officer shall, for the purpose of bringing about the settlement of dispute without delay, investigate the dispute and all matters affecting the merits and the right of settlement thereof, and may do all such things with inducing the parties to come to a fair and amicable settlement of dispute. Number 3, if the settlement of the dispute or any of the matters in dispute is arrived at in course of the conciliation proceeding, the conciliation officer shall send the report to the appropriate government for an officer authorized in behalf of the appropriate government, together with a memorandum of settlement signed between the parties. So that's a settlement at that. Number 4, if no such settlement is arrived, the conciliation officer shall, as soon as practicable, after the close of the investigation, send to the appropriate government a full report stating the steps taken by him for asserting the facts and circumstances relating to the dispute and for bringing about a settlement thereof, together with a full statement of such facts and circumstances and the reasons on account of which, in his opinion, a settlement could be arrived. Number 5, if, on a consideration of a report referred by subsection 4, the appropriate government is satisfied there is a case of reference to a board, which is the tribunal in your lordship, it may make such reference. Where the appropriate government does not make a reference, it shall record and communicate to the parties concerned thereof. A report under this section shall be submitted within 14 days of the commencement of the consultation, such shorter period as the may be fixed by the appropriate government, provided subject to the approval of a consultation officer at the time of submission of the report may be extended by such period as agreed within the right of the dispute. So my question is, Your Lordship, if the conciliation which apparently had failed, all he could have done is assigned the appropriate authority to take an action. The entire issue relates to labor. The entire issue relates to worker. There is no problem from 21 to 22. And I'm still saying this, that there is still no problem for working to happen. But the threat that I get today in terms of what has been happening since last 6-7 months, I cannot run this without any kind of a permanent settlement. So today, the problem is that if this order, which has been passed, is allowed to in the lockout goes tomorrow, they have already threatened us that you have to reopen the garden and start working in terms of this order, which has been passed.
And the DC has passed the 144.
Yes. That has been passed, Your Lordship. I have to give you a date. It's passed on 4th of April, 2024.
Where is that?
Yes. 64.
Anything else?
Yes. This. It's the Punjab and Haryana High Court judgment. I'm relying on the relevant paragraph 6, 7, which defines the power of the conciliation officer. Number 6, paragraph number 6. By reading the judgment cited by the learned counsel for the petition, it categorically emerges that the constitution officer is not competent to adjudicate upon the dispute between the management and its workmen. He is expected to assist the parties to arrive at a fair and just settlement. He cannot adjudicate various points at the issues between the parties. The statute has only conferred the power to him to persuade the parties and to induce them to come to a fair and amicable settlement. He can take appropriate steps as he thinks proper in order to induce the parties to come to a fair settlement. The statute expects him to keep in view his forceful dispute outside by opinions and powers persuasive to persuade the parties for a settlement for the dispute outside the tribunal provided by the Act, and on failure of the parties to come to the settlement, he is to send the report to the state
Where are you jumping here and there?
No, I'm reading paragraph 6.
Yeah.
I'm reading 6 lines from that paragraph.
Yeah.
The statute accepts for him keeping in view
No,
his
where is the statue? That's not
Step 8, like
the statue.
Eight.
Right. Okay.
Yes.
Yes.
The statute expects for him to keeping in view his forceful opinion and power of persuasion to persuade the parties for a settlement of their disputes outside the tribunal provided by the Act, and on failure of the parties to come into a settlement, he is to send the report to the state within the statutory period fixed, and if not extended by a mutual agreement, setting forth the point in issue, laches, and the reasons for the failure of the conciliation. It is only the appropriate government who's authorized, after considering the report, whether to refer the dispute to the tribunal set up under this Act. The conciliation officer neither discharges his judicial or quasi-judicial functions. He acts as purely administrative. He is not expected to return any finding. The object of Section 12 of the Act is ascertain what are the disputes between the parties which affect the rights of theirs, even if some of the settlement is arrived at between the parties before the conciliation officer. The same cannot be termed as an order recorded by the conciliation officer, or if it fails within the definition of the award as defined under the Act. Even this settlement is required to be reported to the appropriate government. His function is purely incidental to the steps towards the industrial adjudication. His functions are neither parameter or they bear a character of the functions of the industrial court of tribunal. His functions can be compared to that of an investigating officer. More or less, he is required to investigate the point of controversy between the parties to cause and the reasons for which not coming to a settlement. Section 2K of the Act defines particularly the dispute with an individual to an industrial dispute. So the powers are very clear. He cannot adjudicate. He can obviously persuade two parties to come for a settlement. And if the settlement doesn't happen, he still has to put up a report. And if the settlement happens, then also the report will have to be taken. In terms of it, which, with all due respect, the order that has been now passed at page 79 is without any jurisdiction.
Anything else?
First of all, Lordship, my learned friend's client is not the employer. He entered into this affair in terms of a deed of agreement, which Lordship will find a case within. The tea garden is under the position of this authority, the Provident Fund, the Commissioner of Provident Fund, in terms of a order of a recovery officer. Respondent number 3, page 4, Lordship can see the respondent number 3, the Secretary of PF Commissioner Assam Tea Employees Provident Fund Organization. This organization is under possession of this garden.
Page 3.
Cross title, Lord.
What time?
Respondent number
Under probably under the number 3.
under 3. So here the agreement, this organization inducted him to run the tea garden as an administrator. Page 29, Lordship will kindly see the deed of agreement entered on 22nd day of December 2021. This is the deed of agreement. Next page 30, last paragraph. Whereas the first party is the PF organization. Being the recovery officer, Assam APBPFO, Guwahati Inspectorate Office has been appointed for looking after and manage the affairs of Fatimabad, a unit of Chaudhary Tea and Agro Industry, which is under order of attachment issued by the recovery officer. So there was some
Just
use.
a minute, who is the first party?
The first party is the respondent number 3, additional PF commissioner.
That is the recovery, being the recovery officer.
So recovery officer directed and entrusted this garden to the commission, PF.
Ah.
Because they were used under the act, there's a specific act also for that purpose. There were dues, so the garden owner could not pay the necessary statutory dues, therefore it was given to them. At first time, there was an order for the recovery officer, and the organization themselves cannot run it, so therefore they engage the second party, who is the restitution again. It's a limited purpose. Whereas the first party being now coming to page 31, last paragraph. Whereas the second party being desirous to manage and run the garden further had approached the first party, and first party, after considering every aspect and as per clause 1 of the deed of agreement, dated 1/4/2020, appoints the second party to look after and manage the affairs of the aforesaid tree garden, and parties hereby and under hereunto have entered into an agreement with the following terms and conditions. Various terms and conditions were there. And if he fails to do it, he can walk out also. If he cannot run it, he has every scope under this agreement to walk away from the scheme. So therefore, he was running the show and there were some disputes. We do not disagree to that. But he do not have the power to lockout order. The lockout order has to be issued by the employer. He is not the employer. If Lordship is to look at, I'll come to section 12 also. But Lordship will kindly come to the Industrial Dispute Act, section 24 first. Illegal strikes and lockout.
Yes.
A strike or a lockout shall be illegal if it is commenced or declared in contravention of section 22 and section 20 or section 23. Now coming to section 22, previously prohibition of strikes and lockout. No person employed in a public utility service shall go on strike in breach of without giving the employer notice to strike. That is from the employer side. And number 2, no employer, this is what is relevant in our case. No employer carrying on any public utility service shall lock out any of his workmen without giving them notice of lockout hereinafter provided within 6 weeks before lockout, within 14 days of giving such notice, before the expiry date of lockout specified in such notice, etc. So he should be first an employer and he should give notice. Now, where is the notice they have? Abruptly, when the conciliation process is going on, abruptly he has took the lockout notice and closed the garden.
Let us see the lockout notice.
Page 66. 18/4/2024, Annex 13. So there's a narration. It may read it. This is to bring to the knowledge of all concerned of Fatemabad Tea State, including workers, staff, and all staff members, that after unauthorized absentees from their work by all workers on 2/4/2024 to 6/4/2024, the garden reopened on 8/4/2024, but the workers have deliberately worked till 2:30 p.m. instead of 4:30 p.m., resulting in huge loss to the garden, and due to which we are behind more than 20 round days with long tea leaves because of these go-slow practices which badly impacted the outcome of the crop. Again, today at 12 noon, some of the workers, staff and staff members without prior information have unauthorized harass our company's executives at factory office premises and harassed him unnecessarily from where local police rescued. But the entire area of the garden is under CRPC 144 HMD around in garden area has been restricted by the district magistrate stated 4/4/2024. But till now, no concrete action has been taken by the police administration. And from 16/3/2024, we are not getting proper protection to run the garden, for which huge loss incurred by the garden and its management, despite that we have cleared all the wages rations on time till 13/4/2024 and managed the things with the thought that the normalcy will resume. But today's incident has put us at insecurity of our executive. And in this scenario, how long we will manage to pay wages, rations, salary, etc. to the workers from the coffers of the company, as normal work is not being done by the workers for the greater interest of the garden and its workers. By going through all above, the company has decided from tomorrow, that is 19/4/2024, there will be no plucking and no any garden work till the matter resolves and necessary action taken for today's incident for the safeguard and safety of our executive. However, the workers who are at work in the factory will continue their work till completion of today's leaf manufacturing. Then the garden will be declared as lockout till the resolution of the matter with the help of the administration. However, all emergency services such as hospital, ambulance, powerhouse, hospital, emergency service staff are exempted from the lockout. There will be no work, no pay for the entire period. The decision is taken with the prior permission of the administrator of the garden. So the manager issued it with the approval of the administrator. That is the reason. This is so clearly, it is in violation of all the statutory laws. Number one. Number two, he is not authorized to do that also. Even suppose the PF organization, they want to declare a lockout. Even I cannot do it.
Only problem is it has been done.
It has been done. Therefore, what the authority has said, that lordship, another aspect is there. Here is the PF authority wanted to put the garden on auction. He went to the civil court, got a status quo order, and he is enjoying that status quo order now. We want to solve all this problem long time back. Now he cannot have all the benefits. He do not want to run it, let him go. It should go away. But the garden should run. There are more than 400-500 employees there. Everything will get into a stalemate. And as a result, a human problem will arise.
Okay, now one aspect. It appears that the lockout is not proper.
Absolutely.
Similarly, it appears that the lifting of the lockout also is not
So
proper.
that I am submitting. 12/2. The power is there.
Or
Power. 12. He is a part of that conciliation process. 12/2 says,
Yes.
the conciliation officer shall, for the purpose of bringing about a settlement of the dispute without delay, investigate the dispute and all matters affecting the merit and right settlement thereof, and may do all such things. This will bring into this also. May do all such things as he may deem fit for the purpose of inducting the parties to come to a fair and amicable settlement of the. He is not settling any dispute till now.
No, but then
This is a blackmailing tactic adopted by the deputy.
there is one thing. The conciliation effort has failed.
It has not failed. It is still going on. Oh. When
Where is that conciliation effort? That is at page 75.
started in 2000 February. It is going on, ongoing process. It has not culminated. And therefore, the impugn order, lordship, the first paragraph, my learned friend read only first few lines, but the second part is not read. May I please, lordship? Page 79. The impugned order.
Yes.
Revocation of the lockout at Fatemabad Tea Estate. This is to notify to the management of Fatemabad Tea Estate that, as per the legal directives and instructions provided by the relevant authorities, the lockout that was declared by the management of the tea estate is to be immediately revoked. Pausing here for a moment, lordship. The relevant authorities also asked. We also instructed, don't go for lockout. It is our property. You are just managing, you are an administrator. You cannot administer, you can walk out. Next paragraph, Lord. The decision to revoke the lockout is based on the following grounds. The lockout was declared without proper justification or adherence to legal procedures. As per the civil suit title suit number 09 of 2023 and mixed case K 20 of the 23, filed by the administrator, that is a writ petitioner of Fatemabad State in the Court of Civil Judge number 1, Kamrup Metro. The matter is under sub judice and both the parties are instructed to maintain status quo as per the ongoing legal proceeding. It is very critical, very important, Lord. This part has been skipped. So when there is a direction of the court, he has to abide by that also, that you have to maintain status quo. So you cannot run away that way. And there will be a human problem and there will be law and order situation which will arise now. When 400-500 families will not be able to get their daily, weekly wages, what will happen? And we cannot also step in the government. I am also appearing to the state of Assam also, as well as for the PF. Do not have any conflict. So we also cannot do anything because there is a stay order of the civil court. We cannot give it to third party to run it also. We ourselves cannot go and run it also. It is his creation. And he has no authority to declare lockout.
I don't know if prima facie whether theft can cover lifting of a lockout. But at the same time, it appears that you could not have declared a lockout.
Go by the authority's power. It would obviously overreach the power of a tribunal.
No, that is all right. But
is
at the
number one.
same time, that is one aspect. That is
Number
the
one.
secondary aspect. The first aspect is, of course, that is something could be challenged. But you could not have in the first place declared a lockout.
May I say? When I'm running the PhD, which has been given to me as a state by a department, I'm paying wages, I'm giving PhD. I'm doing everything that is for the welfare.
No, but there could be notice of
That I would like to slightly differ from what my is saying. If the lordship is giving to me, that I just like to impress on your lordship what is actually a public utility, because that is the difference. when it comes in-
what is the
Yes.
public utility?
Would your lordship come to 22 that my lord senior counsel just read? It says no employer carrying on any public utility service shall lock out any of his workmen without giving them notice of lockout, as wherein after provided within 6 weeks from the locking out, 14 days from giving such notice. Now, your lordship will come to what is public utility.
Correct.
Yes, that is defined, your lordships. To N. So the procedure is laid down. If it is a public utility. 2N. Public utility services means, number one, any railway services for any transport services for carriage of passengers or by goods by air. Number, any services in or in connection with the working of any major port or dock, any section of an industrial establishment, on the working of which the safety of an establishment or workmen employed herein depends, any postal and telegraph or telephone services, any industry which supplies power, light, and water to the public. I'm still trying to find that in. It's absolutely at the end, your lordship. It says public utility service end.
Yes, of course.
Yes,
It is railway.
yes. Number one is the railway services. Over the top, any services in or in connection with the working of any major port or dock, any section of an industrial establishment on working of which the safety of the establishment or working workmen employed herein depends, any postal, telegraph, or telephone services, the industry which supplies us power, light, or water to the public, any system of public conservancy and sanitation, any industry specified in the first schedule, I'll come to that, your lordship, which is appropriate government need if satisfied that the public emergency or public interest is so required, by notification in the official gazette, declared it to be a public utility service for the purpose of this act, for such period as may be specified, provided the period so specified shall not in the first instance exceed 6 months may, or in light of the notification be extended from time to time, any period not exceeding more than 6 months, at any one time, if in the opinion of the appropriate government, public emergency or public interest have required the extension.
Let us see this first schedule.
Yes. First schedule. Industries may be declared to be public utility services under subclause 6 of clause N of subject. Transport, banking,
So SC is not included.
yes. So that's number 2. At no point of time was the intent to stop working by the management. If today also, as I said in the lockout, the only reason I'm putting in this lockout is for the protection of people. If your lordship protects us, there's no problem. The tea garden can run. It was never the management who raised these disputes. The disputes came, yes, there are disputes and which needs to be decided. But today, let me say your
How many persons make up the management?
very clear.
Because if your concern is the safety of the management, and if it's a manageable number of people, maybe the state can provide security.
Absolutely. Will be more than. But if I
So if that can be done, then we don't have to interfere.
but the orders get made,
Because
the order will pass the labor officer. That is.
that's how we will settle that.
That protects the sure, such security problem.
Yes.
We provide security and we'll give proper appropriate response for it. Then what will be stated, right? But in the
Okay, but in the meantime, we will stay the order. We will stay the order, but then we will stay.
the Lordship
your order.
is going to stay the
We
order.
stay your order. We stay
Both orders I have no.
both orders.
Both
We'll-
orders
we'll-
I have.
We'll not.
If Lordship in case, suppose his order is there
Uh.
and Lordship stays it,
No, we'll stay both.
then it is fine. But my third option, what I would like to suggest, if suppose Lordship is to stay it, the second order, then Lordship would have to, my submission with the Lordship would be to give us the liberty to engage a third party to run it. Maybe we ourselves,
Not in the middle of dilapidation.
absolutely,
That's a different.
we do not want the garden to stop. That is our only concern. Otherwise, at the end of the, because we face lot of trouble with the 14 gardens managed by Assam Tea Corporation, which belongs to government. We paid so much of money without getting any work. Here also the same thing will come up at the end of the day. If it is not functioning. So Lordship, if stay both the orders, I will be more than happy.
And one thing is that it should be ensured that the workmen should work till around at 4:30 of. But their problem is that the workmen are working only till 4:30. And that's not
Mr. Lordship, that is the skill you will have for
the human management.
personal management.
If your lordship was from your lordship, I'm sure that you make more of it. That's another complication. Because ultimately the entire process is just wanted to, we don't want to have this one. if your lordship will this also indicate that there could be another condition. But that is what it,
I don't know, because,
also the lordship.
you see, I believe there is some, civil case also pending.
It's status quo. He is violating them.
That's also the option. I'm running the regarding. That is how I have to.
And there was a status quo order passed,
But not in regard to the running of the car.
which
No,
has-
the terms and conditions of the deed of agreement.
That's the option. I have faced the option. So running of the car.
In respect of the conditions of the agreement. The agreement that he will run, the agreement allows him to run the garden. So, case 43, that operating. In view of the above, I am of the considered opinion that interest of justice will be served if both the parties are directed to maintain status quo in terms of the conditions of the agreement dated 22/12/2021 till next year. I think it is still complete.
agreement is the running of the garden.
Yes, by which he entered into the garden as an administrator.
Before that, the last line of page 42. However, on that day upon consideration.
Just a minute, page 42.
I'm reading page 42 of the last.
Yes, yes.
And then over the top, page 42.
How about, yeah.
Made the learned counsel of it that the key option notice has been kept in form. And there is no chance of immediate key action. This court abstain from parties effective on the petition. The court reads the date of issue to contribute to the already have the court. They have not been. So yes, the option that was. Great, maintain status quo on that way. So with all due respect, it could be read that the administration stuff is always going to have to be. It's here by.
Anyway, from your submissions, from both your submissions, what has fallen from your lips is that you want the tea garden to continue. The only reason for the lockout is the safety that is to be provided to the man. That's all. So with once they are agreeable to provide protection, then there's no question of, there's no requirement of putting the tea garden in a lockout mode. And just tell me one thing, if it's locked out, if it's a lockout, then what happens? They don't get paid, the workers.
No function,
They have said, no work, no pay.
no work, no pay, no work at all.
When keeping that angle also in view, and since you want you want only the safety of your management.
I had no other function. That's my quote.
Yes.
But your lordship, it's here, page 73.
Ah.
The last paragraph.
Yes.
I am bound to take some hard steps to stay right of my activity and whether for workers and the families and accordingly. Now, so and so has informed regarding taking up the maximum savings of various of these. After the expiry of lordship of contract demand, you will be this report. So they are saying 750 plus.
Who is this APEPFO?
That is the.
Huh?
Provident fund.
That's at number 3.
Number 2. So we'll provide security. for them.
Yes. But then do we direct or you direct? You tell.
Lordship will give an observer. The SP or the deputy commissioner.
Both. Because one is they are both
Adequate. That word will be submitted.
and their status report should be submitted by you.
Yes. Because whole thing is that because of the model code of conduct, the government also directly cannot get involved. But till first week of June.
I don't know, you can always file applications, whatever, if you don't get enough security. Heard, Mr. RB Pukan. Huh? You're a senior?
No,
No, one is enough. Everybody wants someone to assist him. Mr. RB Pukan. Then it passes for the petition. To submit that the order dated 22/4/2024 passed by the labor officer cum conciliation officer Pokraja, revoking the lockout order passed by the petitioner, passed by the petitioner on what order it is?
18/4.
18/4/2024. If we set aside, in as much as the said labor officer cum conciliation officer does not have the competence or jurisdiction in passing an order in excess of the powers provided under section 12 of the Industrial Dispute Act 1947. The petitioner's counsel submits that the petitioner is an administrator of the Patema Bharti estate on the basis of an agreement executed between the respondent number 3 and the petitioner. The respondent number 3 being the owner, being the
Custodian.
of the safety guard.
Under attached.
Huh?
We have attached.
Next up. The petitioner, next up, the petitioner's counsel sub that due to various problems that were being faced between, that were being faced, that were being, I think that due to the various issues and demands of the workers of the tea garden, comma, an attempt at conciliation has been made between the tea garden workers and the management on 3 occasions. Comma, the last one being held on 22/4/2020. However, no conciliation could be made up between the parties. It submits that in view of the workers not working as per the time period provided by the petition, and as there was a danger to the life, to the life of the management, comma, the petitioner had issued a lockout notice on 18/4/2020. However, the labor officer, some conciliation officer, Pokraja, had by the impugn order dated 22/4/2020 revoked the lockout notice, comma, in excess of its jurisdiction. Next step. On the other hand, the learned AG attempt Mr. D. Tech submits that in terms of section
24, 23, 20. What's what up?
in terms of section 22, 23, and 24 of the Industrial Dispute Act, 1947, hereinafter referred to as the Act. Notice has to be given to the workmen prior to issuing a lockout order. No lockout order has passed to the bill. He further submits that, he further submits that there is a case with it. No, that is anyway, that's with the that will not. That is- Anyway, I can reflect
Yes,
that.
Lord, the status quo regarding the terms
He
and
submits
conditions
that.
of the
He submits that, besides the above, the civil judge number 2, Kamrup M. Wati, had passed an order dated 24/5/2020 in this J20/2020, directing the parties in the suit to maintain status quo in terms of the particulars of agreement dated 22/12/2021, by which the petitioner has been made an administrator of the TICA. He submits that in passing the lockout order, the same has been made in violation of the status quo order passed by the civil. Mr. Visakia submits that as the major concern, as the only concern of the petitioner pertains to the uh, physical danger that is posed to the management if the tea garden is left open. The administration is bound to provide protection to the management if and is to provide management to the management to protect them. Without going into the issues raised, this court is of the view that the submissions made by the counsel for the party only pertain to only show that the lockout order has been made only to protect the lives of the manager. As such, if protection is provided by the district authorities to the management of the tea garden, the same would take care of the issues raised by both sides. Uh, the this court is thus of the view that the deputy commissioner and the concerned SP of the district should provide adequate security to the management of the petitioner tea garden to ensure that the tea garden is open and in working condition. So, with this regard, Mr. D. Sankar, the addition AG submits, the AG submits, he will inform the concerned district officials to provide adequate security as directed by this. Uh, uh, List this matter after 4 weeks. 4 weeks.
That is the post of lockout order.
Consequently, uh, in view of the above order, the lockout notice dated 18/4/2022 and the impugned revocation order passed by the labor court, sub conciliation officer of Raja, dated 22/4/2022 are both, shall be both be kept in abeyance. So,
Hello.
that's all. Anything else?
Will provide security today itself. Let them start the functioning of the garden.
Wait a minute. Okay, I will you do that.
That line.
I will, you say the learned AG submit that security will be provided to the management of the petitioner's tea garden. Today. From today,
And they should open it up for them. We can
full stop. In view of the above assurance given by the additional AG, no, the AG, the additional comes so many times now. The AG The landed AG, the tea garden should start functioning and be kept open from tomorrow.
Highly.
Yeah, we'll do that.
Subject to the security to be provided by the